And that's the beauty of starting with the Lord and starting with the most important thing, matter spiritual, because now everything is working, even the microphone is working. So colleagues, friends, allow us to start with the security protocols, then we shall go right into the program. Karibu.
Thank you very much. Good morning, everyone. Sorry for the little bit of that glitch and everything is well. My name is Daniel. I work for security department in Pullman and Maki Hotel. I just want to take you to give you an overview of what can happen in case of emergency. We are not anticipating any form of danger, threat. We have never had any major threats before. And just to put you in the state of awareness, also preparedness in case we have any emergency. No emergency announces that they are coming, they come unannounced. Any occurrence can take place in terms of fire, terror threat, but we really need to know in our mindset that what can we do in case of such an occurrence. As you can see, within this building, within this room, we have two indicators for emergency exits. Right behind me to the right, you can see a green signage, somebody running. That is to say that in case of emergency, in the process of evacuation, people normally go out very fast. That is to get away from the danger. So right from the main entrance where you came from, there is also a signage, an emergency exit signage, that shows you how to go out. So in the process of evacuation, of course, you'll be guided to have enough trained fire marshals in case of fire, who will guide you all the way to the fire assembly point, right outside the perimeter wall at the exit gate. There is also that is the primary fire assembly point. There's another outside. That is if you leave out this way, back of the house corridor. I believe in case of emergency, that is when situations probably there will be a mix-up of movement due to the situation. This one takes you out to the back of the house. There's a long corridor out to the receiving area or the staff entrance. That one takes you to the lobby area where you'll be guided up to the fire assembly point. I want to believe that even as we are seated here, there are basic amenities like toilets that you people should be conversant with, the locations where they are. If you want to go out for a call, just the main entrance, downstairs, turn left, immediate left. Now, after turning left, it will be on our left side. You'll see toilets there, both ladies and gents. Want to bring to your attention that our security setup comprises of armed security. We have security who have firearms. So if you see a GSU officer maybe passing around, it's not a state of danger. It is he's protecting your life. So don't panic if you see security and armed security around. We have enough trained first aiders in case of any injury. So if in case we are not anticipating that, but if it happens, it will be taken care of. I also want to bring to your attention that we take care of items, especially the bulky items that you leave behind during lunch break. We have a roving patroller and enough security team who will take care of that. We'll be on the watch out. But in talking of the same, we also advise that you take care of your personal effects. Personal effects, that would mean phones and very portable items. Kindly work with them and take care of them. I believe, and I have assurance, I don't just believe, I have assurance that you are safe. If you're here, enjoy your session and enjoy your time. Thank you very much.
Thank you. Let's give him a handy clap. Asante sana. Now that we know of our security briefings, we know of our safety, allow me to very quickly introduce myself so that we can go to the round of introductions. So we are going to state our name and the entity from which we come from or the entity that we represent. I don't know whether there's another mic going around, but allow me to start with myself. My name is Desiree Njamoya. I work with the National Gender and Equality Commission as the Assistant Director for Legal, Complaints, investigations and redress. So I would like us to very quickly, so that we save time, we follow that trend from behind. Your name, entity that you represent. Thank you.
Good morning, everyone. My name is Gadai Umenya. I come from ICTJ, International Center for Transitional Justice. Many of you know my colleague Agatha. I'm here representing her, but I work in finance and programs.
Good morning, everyone. Barbara Owino, Legal Counsel, FIDA Kenya.
Good morning, everyone. My name is Leticia Mwavishi. I work at the Federation of Women Lawyers, FIDA Kenya, as a policy and advocacy officer. I work at the programs department. Thank you.
Good morning, everyone. My name is Namulanda. I work with the Kenya Legal and Ethical Issues Network on HIV and AIDS, KELI in Kenya. I work under the Strategic Litigation Unit.
Good morning, everyone. My name is Peggy Rasiga. I am with the National Gender and Equality Commission under the Department of Communications.
Good morning, everyone. Salome Wanjiku is my name, from National Gender and Equality Commission in the Communication Department.
Good morning, everyone. My name is Wallace Nderu from Defenders Coalition. I support research and advocacy.
Good morning, everyone. My name is Lilian Amsolo, Shield for Justice.
Good morning, Eunice Wanjiku, Inuka Kenya NGEC.
Good morning. My name is Jane Githiri from Women's Empowerment Link. I coordinate our Elimination of Violence Against Women and Girls program. Thank you.
Good morning. Masi Atole, a member of the Survivors of Sexual Violence in Kenya Network.
Good morning, all. My name is Simon Malenya. I work with Independent Medical Legal Unit.
Morning. George Mundi, advocate, volunteer, WKF. Thank you.
Good morning, everyone. My name is Samuel Kiptalam Buntich, Kenya Police Service, Directorate of Legal Affairs. That's what I represent. Thank you.
Good morning, everyone. My name is Yvonne Oyeke. I am an independent consultant, but also a member of the Coalition Against Sexual Violence.
Good morning. My name is Martha Njoki, ED, she's a Freak Hub.
Good morning. Alice Karanja, a survivors of Network Kenya with in Kiambu County.
Good morning, everyone. My name is Wangu Gitahi. I work at KELI within the Strategic Litigation Department.
Good morning, everyone. My name is Winfred Wangoi. I am a member of SSV Kenya, that is Survivors of Sexual Gender-Based Violence.
Good morning. My name is Winfred Kimeu. I work at Crown Trust Community Advocacy and Awareness Trust as the program's lead.
Good morning. My name is Salome Nduta. I am with the Women Human Rights Defenders Hub.
Good morning. My name is John Juguna. I'm from Gender Violence Recovery Center. I support medical and legal service.
Good morning. I'm Stephen Masharia. Natoka kwa Survivors Network Nairobi.
Good morning. My name is Corazon Ayoma. I work for Trust for Indigenous Culture and Health, in short, TICA. I support programs, also lead the Adolescent and Youth Program.
Good morning, everyone. My name is Flomena Mushike, SSB, Nairobi, Kenya.
Good morning. Fatuma Kuyeya from Independent Medical Legal Unit. Thank you.
Good morning, everybody. My name is Esther Waweru, SSV Network Nairobi.
Good morning. My name is Nicole Moina, National Gender and Equality Commission, Legal Department.
Good morning, everyone. My name is Sheila Cheruiyot, National Gender and Equality Commission, Legal Department.
Good morning. Zafida Chege is my name from the National Gender and Equality Commission, and I'm at the LCIR department. Karibuni.
Good morning, everyone. I'm Juliet Owala from the National Council on Administration of Justice.
Good morning, everyone. My name is Julie Kamsa from the National Gender and Equality Commission.
Good morning, everyone. My name is Jacob Atel. I work for Usalam Reforms Forum.
Thank you. Good morning, everyone. I'm Dr. Myrna Kalsi. I'm a forensic consultant, and I'm happy to be here today. Thank you.
Good morning, everyone. I'm Dr. Kizi Shako, a forensic medical practitioner. I'm happy to be here.
Good morning, everyone. Mpaka mtanisalimia vizuri. Good morning, everyone. My name is Wangu Kanja from the Wangu Kanja Foundation. I will also allow my colleagues to introduce themselves.
Good morning. My name is Rasat, so also part of the Wangu Kanja Foundation. This is just to give you a heads up that we'll be taking photos, and we're also streaming the conversation for documentation purposes. So I know we have all signed our attendance list. Did you read at the bottom what it says? Sandy, then I don't need to continue. So we can go next.
Okay, good morning, everybody. Sorry, just some technical matters. You want me here? Okay, so we will be going through, basically we'll just go through mainly the scope and magnitude of forensic sciences in its entirety, so that we can at least all be on the same page regarding what we have and what we are trying to have and where we should be going, or hopefully that what we intend to see by the end of the enactment of a forensic science bill or act. I will warn you that there will be some graphic photos, but we shall warn you beforehand so that you can close your eyes or whatever you need to do, just so that you're not triggered, for those of us who can be triggered. Yeah, so then after that we will go through the forensic science bill and what the gaps that we have observed, and some recommendations regarding what can be changed and modified, revised, or added. Yeah, thank you. Why do you need to send this to him?
Good morning, everybody, once again. So I'm Dr. Kelsey. Dr. Kizzy and I'm sure probably have interacted with her. Some people we have met before. Kizzy and I have more than 15 years experience each in this field. We have worked over several contexts in and out of Kenya, handling various matters relating to torture cases, forensic death investigations, interacting with criminal investigators, understanding how forensic evidence is supposed to be managed, the standards that apply to it, and the rights of prosecution, but also the rights of the defense to access and challenge, scrutinize and challenge forensic evidence for the right to a fair trial. So we're going to present today. I'm not sure if some of you have ever heard any one of us present, but we will have to start by explaining the challenges, the system, the way it currently is. It's highly technical. There will be some documents sent out to your emails so that you can read. There's quite a bit of reading that is required in terms of this subject, in order that you could digest this information and actually understand, or better understand, what we are sharing with you today. So those are our contacts, and you can get in touch with us if you need to. So this is the general outline that we have. We will do the intro, we will do a preamble of the bill. We will go into the scope of forensic science, because the bill talks about forensic science. We will discuss the legislative or policy justification for such legislative development. We will go into the regulation part of forensic science. We will also provide examples of forensic governance models, and then we will do a review, a more detailed review of the bill itself and the considerations that we need to think about for the legislation. And also part of the discussions will include the impact on crime, human rights violations, and the management of forensic evidence. So today is just a chance to allow you to just absorb information regarding this field. So Dr. Ari and I will interject and work together and present together. So the field of forensic science is about the application of scientific methods and techniques to the investigation of crime, which may also be human rights violations, whose findings may then be produced in a courtroom. Not all cases end up in court, or all forensic evidence end up in court for various number of reasons. The term originates from a Latin word, which forensis, which means of the forum or public. So in ancient Rome, trials, public debates, judicial hearings were held in the public square known as the forum. And so as we come through the continuum of evolution in terms of the terminology of forensics, we encounter its interaction with evidence for a legal process. And so evidence is information and objects, we can just simplify it that way, subjected to a scientific process, forensic, applied to an investigation in order to contribute to a legal process. And evidence, we said, refers to information or objects that may be admitted into court for consideration when hearing a case, and evidence can come from various sources. So with the same definition, you can see there are different types of evidence here. This satellite imagery is a form of evidence because it can tell you about what's going on in a conflict. You can see this image here, which is a picture of an injury in the genitalia, in the female genitalia. Then you have cases of injuries, what we call tramline bruises. For example, if I hit someone with this microphone, it will produce what we call a tramline injury. Because it hits this part and the blood would flow this way and that way. So you would end up with 2 red lines, that kind of injury. Or lash marks in cases of living injured persons, mass graves in terms of dealing with the dead and the condition of those remains, which may now be skeletonized. And that doesn't mean that there is no investigation into that. Investigation on electronic evidence, which means video, CCTV, audio analysis, digital evidence like extracting data from telephones. Also, you can see the fired bullets, the casing. You can see there could be evidence relating to financial crimes. Tattoos could be evidence. You could have a pacemaker or a prosthesis. You can have a fingerprint. You can have DNA. You can have babies born from rape. You can have wildlife crime, environmental crime. So forensic science would be applicable to so many different types of crimes and human rights violations. So the role of a forensic specialist, the bill, you will see it talks about analyst, but just for the way our field is, a specialist would work within the criminal justice system. They practice a certain forensic scientific discipline, and in that scientific discipline they are going to follow this chain of at least 7 events, which is identify that specific type of evidence, collect the evidence, document the evidence, which includes a chain of custody form, having inventories, like a photographic inventory, having the forms like we have the P3 form, the P23A form, we have the police fingerprint form, we have different types of forms, which are evidence collection tools. Then number 5 would be the analysis of the evidence. Number 6 would be the interpretation or the opinion formulation of that analysis of evidence. And then number 7 would be how you present or report the findings, whether they're written or oral, and as an expert witness offering testimony. So all this means that legislation covering the field needs to look at how evidence is identified, how it's collected, how it is documented, how is it preserved, how is it packaged, who pays, what is the legislation on the procurement of packaging, how is evidence analyzed, where is it stored, are there evidence warehouses, is there an evidence tracking system? If you're tracking kits like sexual offense, assault kits, then, who provides those kits? Are they provided by the hospital? Are they provided in law by law enforcement? Who manages the data in terms of forensic information management systems? Who are the specialists? How are they trained? Or the analysts, how are they trained? Does their testimony hold, is it credible in a court of law when they're interrogated about their profession? So there is a whole value chain for the management of forensic evidence in terms of its very specific crime that you're dealing with, whether it's financial crime, wildlife crime, environmental crime, sexual offenses, or you're dealing with a death investigation, or you're dealing with a torture case. So it's a multidisciplinary field. It functions through, like I said, specific specialist scientific disciplines, and they are basic fundamental principles that apply across the science. So each specialist will provide a piece of the puzzle. That is, they will provide an estimate of the evidential value of their investigation. So Evidence doesn't officially exist until someone recognizes its potential value to the investigation and prosecution of a crime. All evidence is supposed to be subjected to a scientific process. This is what undergirds a formal criminal justice system, which Kenya has taken up. So evidence management is the undergirding, is the engine of, in essence, of that criminal justice process. So scientific evidence must be preserved, that is appropriately packaged. So for example, if we were to package an improvised explosive device, we would have to first make it safe. That is a specialization. And its integrity, and maintain its integrity, so we're looking at evidence should not be lost, it should not be damaged, it should not be contaminated, it should not be overlooked at a crime scene. And it must be maintained through a chain of custody. That means from every stakeholder to another stakeholder, from every duty bearer to another duty bearer, from health to law enforcement, from crime scene to a forensic lab to the judiciary. There must be a chain of custody, and the evidence must be preserved. So fluid from, for example, a rape case is biological fluid, like semen, saliva. That evidence is degrading with time. It's different if you're looking at a forged document or assessing a document for forgery case. Paper and semen do not degrade at the same time. They have their different time frames for degradation. So the best practice of forensic science is we cannot analyze and interpret for the court or for the legal system what we do not know how to identify or to properly collect. In the cases of sexual violence especially, the interaction of law enforcement and health sectors, that is the source level, that is this area, that's the level of source of generating evidence, medical evidence, clothing related evidence, biological evidence, drug facilitated evidence. So there is a weak link. Forensic science cannot happen without proper coordination, and that coordination must be legally established. We can't leave it to guesswork. And that law must then go into policy and go into practice, go into procedures. So as we continue the introduction, I'll move from that space now that we know the different 7 levels of evidence. And we go into the issue of deceased persons. So we have extrajudicial killings and forced disappearances resulting in deaths. That's in custody, police brutality, the use of indiscriminate or excessive force or excessive force, missing, presumed dead, investigation of mass graves, mortuary management, identification of the dead, which is forensic human identification, and then cause, manner, and mechanism of death, which is forensic death investigation. So we can say, but this is covered in the National Coroner Service Act. The reality is, the trend we have observed is that forensics has been built piecemeal because of different prioritization. So extrajudicial killings is an issue. So we push, we advocate. There must be a policy on management of deaths in Kenya. So we come up with the National Coroner Service Act. While that's a forensic related act for forensic death investigation and human identification, there is no overarching, primary, harmonizing, unifying law for forensics. So we have these different piecemeal legislations. Like now you have the Cybercrime and Misuse Act. You have different pieces of legislation rather than, and while that may be required, so we are building the small pieces, but we don't have fundamentally the overarching law. So warning, there's graphic content for the video. So I'm just going to be very open to discuss with you. I think we have come to that point where we have to share this for your knowledge and understanding. We said evidence is information and objects. So maybe it would be, I hope that you can see and that it's clear. Let me try to, I don't know. Okay. So here we have a 12-year-old girl who was unfortunately shot with what we believe is a long-range rifle during a protest. And so we have, you might not be able to see it here clearly, but this her hair is braided and there is some kind of like indentation. At this point, then we have, you can see this and you can see that. This is like bleeding, hemorrhaging, bruising in the scalp area above the skull. And there is an indentation here and some blood there above the bone of the cranium, which is the skull. And then when we open it, you can see there's a mark here, and it continues to bleed out. When we open that tissue, we find there's an area here of bleeding of where the bullet had entered, and then you have all this hemorrhage when we opened it, and then you have the bullet head there soaked in blood, and you have here the pathologist using a forceps to hold up the bullet head, and there's a mark here. This is the underside of the skull, so this is the top part, and you can see that this is the entry wound of the gunshot, and this is the exit on the underside of the skull. We have a number of issues are presented here. Number one, this is my forensic equipment. The state did not buy this for me. Yes. Well, I'm sure they have some, but the thing is, who is supposed to provide this equipment for the forensic specialist? Who's supposed to generate the barcode labels? This is manual. This is a manual labeling. Yeah. Is the forceps the right tool for the pathologist to be holding this bullet head? Because this has come from a firearm, so it has potentially some markings, and holding with forceps could be damaging those markings. Here you have the bullet head 3 millimeters long. So you have evidence on the bone in the skull of entry of a gunshot, of a bullet head from a gunshot. These are the kind of now potential long-range rifles we are looking at, probably. Yeah, this kind of 7.62, which is relating to an AK-47. And you can see the trajectory of the bullets. So a lot of things matter, the distance from which the firearm was discharged, the stability of the bullet head. And so in terms of a forensic review, because this is now evidence, evidence doesn't stop because the National Coroner Service Act now says that was a death investigation. It doesn't stop there. So we have a forensic review of the matter. So first of all, we have no information related to an X-ray or CT scan of the skull where the bullet was found. That documentation is missing. That is evidence which is missing in that case. So who is in charge of forensic radiology? Do we actually have a forensic radiologist in Kenya? Is there somewhere in law that it says that forensic education is supposed to be financed by the state and should therefore, the financing and the human resource and where does this person work, you know, if you're going to put that kind of investment in human resource. So that information of medical evidence relating to an X-ray or CT scan of the skull where the bullet was found is now not present for this case. Then, so we are missing also the forensic radiology report. The criminal investigator is who in this case? If the firearm is discharged by law enforcement, IPOA in charge, the DCI in charge, and the mandate of the National Commission of Human Rights. So who is in charge, who's present, what's their role, and who's actually not supposed to be in the room? So you have a criminal investigator's report. Forensic death investigator, so you have a forensic post-mortem report. The reason it's in orange is because our form, the post-mortem report, is a pre-colonial document. It is an evidence collection tool that is outdated, not fit for purpose. And there hasn't been a review of this form to our knowledge, unless there is an ongoing review. Then there is a ballistics part of this case. So then we expect a ballistics expert report. The ballistic expert should actually be examining the fired evidence, which is the bullet head found in the cranium. On the scene, there should be an investigation to find out where the firearm was discharged. Is there shell casings? In which area were shell casings found? Who was the firearm issued to? Where is the location of the firearm? Who has the firearm being examined? Now, you have the issue then, who is holding a firearms database registry? Is that a manual registry? There a ballistic database where you have a registration of fired weapons, where it is known the registration of the mark, the ballistic markings of the weapon, of that specific weapon. And then if you have any analysis of gunshot residue. So this person is a doctor, a specialist, a radiologist who has a specialization in forensics. This is maybe a law enforcement person and also maybe a human rights investigator. This death investigator is supposed to be a forensic pathologist. This ballistics expert is a forensic expert in ballistics and firearms. So all these people, this law is supposed to govern somehow all these parts, some of these parts, the laboratory part of these parts. So I'm just trying to share with you the reality of the different sectors in just one case. Living injured persons, police brutality, ill treatment, torture cases, cases of sexual offenses, other cases that might be under the umbrella term of sexual and gender-based violence, non-accidental injuries in childhood, which what we call child abuse, elder abuse, custodial medicine, where you have people in custody, but they are being injured or ill-treated. Warning graphic content for the video. So this is a torture case. We present two cases. One, well, yes, there was a sexual offense here also. So one male, one female adults. This is a report by a well-known hospital in this country, seen by a medical person who is signs by the name professor. And this case we examined this case. I think, Kizzy, maybe it's better you speak.
Okay. So so this is a case of alleged police brutality, and we were asked to conduct an examination a few days after the incident had occurred. Now, because of the nature of this case, there are certain protocols that should be followed, like the Istanbul Protocol. And so what is required is that every single detail of every aspect of the assessment has to be documented, including a very, very thorough history. Everything that the survivor says must be documented. So if you have a 1 month story, you write everything that happened for that 1 month without omitting anything. And part of that assessment requires, of course, taking the history. That alone took us 3 hours to do, just to write down everything. And then we had to look at the medical, any kind of investigations that had already been done. That didn't take us very long to do, but part of it was, basically this was all that was provided. A medical report from a facility in Nairobi. And what I would like to highlight is, first of all, can you read anything there? Are you able to see? Even if you squint. Can I zoom in? No. It's okay. You can't read. We had to really, like, it took a while. Okay, given we are doctors, we understand each other, like, we get it. But it's hard. And in cases like a forensic case, this is not the way it's supposed to be. You have to have very legible handwriting. In fact, in meetings, like especially where we have disaster victim identification cases, forensic human identification cases, disaster meetings, one of the topics on the agenda is how are we going to write? Mirna usually leads that session. We are going to write like this. You have to write. Number 4 is like this, not like this. You know, so that we don't mix up anything, right? And then you can see the history here just says, I don't even know. He was dumped somewhere, reports having been tortured with injuries all over his body. Then that's it. End of history. Examination, swelling and bruises all over the body. Reported that objects were inserted in various canals in his body. Then there was some sentences on bruises over the body, lower and upper limbs, head to swellings over legs and upper limb. Then there were some x-ray findings, and then he was treated with something and something to be followed up at the clinic. Now, here you have no timeline indications. You don't know when this happened, how many days it took, when the person was released, were they given medication, were they on any drugs, were they given any sedatives, were they treated for anything while in wherever this thing was happening, did they walk on those legs that are allegedly hurt, did they not? There are so many questions. What else was inserted? When you say object, what do you mean object? What was the experience? Was there pain? Was there not? You know, all these things are supposed to be captured in such an assessment. Then injuries have to be very clearly demarcated. There also needs to be body charts. Body charts for one to have a proper understanding. You know, when you're in a courtroom and you're explaining, giving evidence as a medical examiner, you need to explain what you observed, how you interpreted it, what your opinion is, if you gave any recommendations, if you needed further tests, and so on and so forth. And everything that we say in a court of law has to be anchored on science. So if I write an opinion, it has to be backed by references. In fact, part of the report should have references. Now, this patient, when we examined him, he actually had about, over 22 injuries. 22 injuries. The report we compiled was how many pages? About 30 pages long. because the history was extremely long. We had numerous photographs, and I think you can appreciate the value of photography. If you just look at that, you can see, first of all, I want to show the yellow bruise. Yeah, what you're seeing being circled there is actually something you'll hardly see in dark skin, which is a yellow colored bruise, which tells us a lot about the timing when this could have happened, the impact, the point of impact, and all that. You also have the rulers or geometric references, which is the best practices for taking photographs of injuries. Photography is also the gold standard for documentation because, as you can see, and we all agree, it adds a lot of value to understanding and getting a better understanding of what exactly this person may have endured. That right there is a ligature mark that's being highlighted. Ligature marks show you it's a bruise, in an elongated bruise and abrasion that shows that this person could have been tied in that position. None of this was captured here. In the lower pictures, on the extreme end, you have a foot that is swollen. We later discovered, because we decided let's do some further tests, if you have assault cases of this nature, there are other investigations that need to be done. This patient actually turned out to have additional fractures that were not captured in this part. In fact, they did, I don't know if they noticed or didn't notice, we don't know what happened. So there was other investigations to give more weight to the allegation of torture because it was in keeping with findings in cases of torture. Then we also used UV light, which brought out the severity of bruising underneath in the soles of the feet, which you could not have seen in natural light. So why are we showing you this? We are showing you this not to blame or to bring others down or to point fingers. We are showing you a case report of the value of knowledge and skills in gathering evidence, interpreting it, packaging it, and producing it in court. Do you understand? Yeah. Next one. This was another case where there was still physical assault, psychological torture, and sexual abuse. The report on the right, the extreme, is that right? Right. Again, you can see the history is very brief. Actually, this is just...
The MRI is confirming. The MRI is confirming.
Okay, sorry. In this case, actually, we were not even able to get a medical report. The patient could not get a medical report from the facility until about 4 months later. So we basically had to subject this person to another set of assessments, right? And then the report was also similar, very few words, someone's, like 5 lines long saying what they endured and what they found, and they were discharged. This report is a report on an MRI that we ordered, right? Yes. Afterwards, because no tests were requested for her, and she had increasing progressive pain and swelling of her lower limbs months after the incident. And there were some findings that explained why there were injuries to the lower limbs, right, to the feet that were not found before. But we knew about it because we had been taught about it. We had learnt it when we were doing our postgraduates and when we have interacted with other forensic practitioners globally. So that revealed other injuries that had not been picked up before. Again, there's a photograph down here showing the right way that photos should be taken. We have measurements, so we are not guessing, saying it could be around 1 centimeter long. I've seen that being done. It could be possibly 5 centimeters long. We are not supposed to do that. And then in this other one, here, we have a log of the photographs. So all the photographs we took, we logged them in a photography log, like an inventory, so that if we are asked, what is this photo, where is it, how many photos were there, what was submitted, we have evidence of that. So again, we are just showing you the value of having knowledge, skills, and being surrounded by or interacting with experts who have more experience from all over the world. Oh yeah. Yes. So what my colleague is telling me is that as much as we hear so much about the National Coroner's Service Act, the Forensic Science Bill, none of this is captured in any of those aspects. There is this misconception that forensic medicine is only for dead people. Only pathologists do forensic medicine, which is wrong. We need to change our mindsets because living people also are encounter crime. Violent crime. We have a lot of defilement cases. We have a lot of domestic abuse cases. We have a lot of abductions, trafficking. All these people require forensic services. All cases of motor vehicle collisions require forensic services. Anyone who was in a bar and found themselves in a forest without their phone, without their car, that is a forensic case because you need to find out were they drugged by what, etc. Do they have injuries and so on. Any child who is abused is a forensic case. So we need to change our mindsets regarding forensic medicine. It's not just for pathologists. So in other words, the Coroner's Act and the National Forensic Service Act does not talk about this. And it should. There needs to be a lot of information explicitly indicating how a forensic medical examination shall be carried out for a sexual offense, for non-sexual offenses, for trafficking cases, for torture cases, for motor vehicle collisions, where there's been intoxication by the driver, etc. All that, including illnesses. If there's a motor vehicle collision with involving a person who's a diabetic, who has had a head injury, all these things have to be documented somewhere to give guidance, including things like terminologies, so that we are not guessing and making a mess. Thanks.
Right, so the point I think we want to drive home is that the National Forensic Science Bill, as it is currently drafted, does not include clinical medicine. Okay? And clinical forensic medicine has a huge scope. It's also not covered by the National Coroner Service Act. It's not covered by the Cybercrime Misuse Act. It's not covered by the Public Health Act. So we will get to a point where you will see the scope. So there needs to be a code of how fingerprints are handled, digital evidence is handled, question documents are handled, financial records are handled. The scope and the magnitude of forensic science is not adequately defined in the current bill as constituted. The bill is quite laboratory-centric. It's a laboratory bill. It's talking about the labs, forensic science labs. It's talking about regulation, and it's talking about chemical weapons. And we already said, I think from Desiree already spoke to that issue, is that those three matters do not constitute the whole magnitude and scope of forensic science. Or is it that we are creating just a new piecemeal legislation for forensic laboratories and attempting to do a regulation of forensic science? And also have the chemical weapons matter be superimposed into, to piggyback so that it can have a legal standing. Issues to do with electronic evidence. So we're just trying to highlight and point out what's major. This report was written in 2021 about the admission of electronic evidence, contradictions into the Kenya Evidence Act. What we're trying to say is we are forensic specialists. We are very specific to our specific disciplines, but that does not constitute the whole of forensic science. So the value of the scientific method. This is science. In science we are supposed to be objective. That is the principle of science. Science is supposed to be objective. And there should be a standardized approach in conducting an experiment with improved results. It is objectivity and standardization as the approach for analysis of evidence. And then we have what method did we use to analyze a fingerprint? What method did we use to analyze a DNA sample in a rape case? What method did we use to analyze a blood sample for drug analysis? Now, that method, is it accurate? Does it actually reflect what it claims to represent in terms of scientific testing? In terms of reproducibility, that means that a lab, someone sitting in a lab in Germany, someone sitting in a lab in Australia, someone sitting in a lab in Guinea-Bissau, someone sitting in a lab in Kenya, in a lab in Rwanda, if they do an analysis of that DNA sample, that they will get similar results. That their interpretation will not be off. That their expert witness testimony in a courtroom will adhere to the qualification, their experience, and their practice. That is, they are proficient in their science. So the issue of forensic science is that we talked about these 7 steps. We can, if we take out the strawberry, that remains still a bowl of fruit. With the strawberry, it's a bowl of fruit. Without the strawberry, it's still a bowl of fruit. In forensic science, we have a coffee machine. We have a system where we start, where we have an input and we have an output. We put in coffee, we put in milk, we put in water, and at the end we get coffee. And that has several processes in the structure of the machinery. Forensic science is like that. If you don't identify evidence in the beginning, you cannot analyze that evidence in the middle, in step 5. And you cannot present on it in step 7 in a courtroom. So if you miss it here, you will not be able to collect it. You will have overlooked it or lost it, or you will not be able to document it properly. And we said evidence is information or object. So this is the problem. Forensic science, when a bill says forensic science, it is speaking to all this across the whole magnitude and scope of forensic science. The reason why this is so important is because you have crime scenes. For example, most SGBV cases, sexual offense cases, you will have the victim come to the hospital. But have you ever asked yourself, today if we did a survey or we did a research and said how many crime scene investigators actually go to the location of where the rape happened? Right. So, but the thing is, do we really know if it's none or some or little or a lot? The reality is that you could have maybe, just saying, you know, hypothetically, let's say we have 20% of victims actually going to the hospital. We have maybe, if it's a high profile case, we have an investigator going to examine the location from the forensic service. You could have 20% at hospital to arrives at medical evidence arriving at the hospital, hoping that the hospital can generate that medical evidence. And against a 1% at the location where you're trying to look for forensic evidence at the location. How much of then that evidence ends up in the forensic labs? Oops, sorry. In the forensic laboratories? Maybe out of 20%, 3%? How many end up at conviction? How much of that evidence is actually utilized by the prosecution? What percentage of that evidence, that what the prosecution, you know, utilizes, maybe it's there's 2%. Does the defense actually have access to the 2%? What does the court end up with initially? So this is what we are saying, is that forensic evidence is across the chain of crime scenes. Even a person, victim or suspect, is still a crime scene. They're a moving crime scene, right? The investigators, are the other party, which maintains the chain of custody of forensic evidence, and they initiate the investigation. The crime scene is where you end up with the source of the evidence. The lab is where you process the evidence and end up with, you start have expert witness testimony as well. Prosecution guides the investigation and utilizes forensic evidence for a decision to charge. The defense will have to scrutinize, access, scrutinize, and challenge the forensic evidence. And that forensic evidence, that testimony, the credibility of that person as an expert witness, and the admissibility of that evidence, all these things work together. So when we talk about forensic science as a legislation, this is what is the implication across any type of crime. Okay, let's go back to, we want to give this example of the GBV. So we have a case of SGBV here, of a sexual offense. The crime scene investigation goes and examines the location for evidence, finds if there are objects of evidence, finds if there is evidence from the victim, evidence from the suspect. And this requires now coordination with even the health institution. So you have here criminal side of investigation by law enforcement, crime scene investigations. If it is a sexual offense or that occurred, perpetrated by someone in law enforcement, then you now have IPOA potentially involved, yes? Okay, then you have clinical forensic medicine, or you have forensic nursing in different contexts. You have the field of examination of living injured persons. You have to examine the victim and the suspect. We have a very victim-centered approach, but we don't realize that the evidence that we are saying is on the victim actually came from the suspect, and we need to be able to link the two in time. Forensic photography. You heard Daktari say it's the gold standard for documentation of injuries. If we didn't take this picture, this person has healed by now. This ligature mark, yes, would not be here. But in court, this will be presented as evidence. So if we do not photograph the genitalia, if we don't photograph the injuries, if we say, oh, you are traumatizing the victim, or you are not, these things have to be explained. And I can tell you, over the years I have worked, even in the most difficult of circumstances, even when families have relatives who have died in a plane crash, as long as someone is actually willing to simply explain to them the situation, you reduce tension by a lot. The realization, what you saw at Utumishi, is because there is a lack of understanding of how to explain forensic human identification in a case of burnt beyond recognition to a parent. That's the problem. Beyond the pain of losing a child, when you can't explain, you will try to use force to push people out because you have no understanding. In sexual offenses cases, you will lose that evidence with time. So you have to collect it here via forensic photography and videography. Even most hospitals are supposed to have a photographic approved device to take those pictures. So who is supposed to give the camera? Is it law enforcement? Is there going to be a budget in law enforcement to put that camera in the hospital? Which hospital will it be? It has to be the place which has a forensic specialist. Where is the budget coming from to train the forensic specialist? Forensic biology, analysis of the samples, DNA analysis from the victim and the suspect, or from samples that may be found. Forensic toxicology, if it was drug facilitated. Forensic pathology, if you have now an SGBV related death or you have a case of femicide, is still forensic death investigation. If you ask how many forensic pathologists are in Kenya, do you know? is a pathologist the right profession to do a forensic death investigation? Pathologist can be a clinical pathologist checking whether you have cancer, okay? But which is the pathologist that must do a death investigation? Forensic odontology and anthropology, when you deal with issues of age assessment and forensic human identification from the skull and the pelvis, women have a wider pelvis because they give birth. Their pelvis is more round. Men don't give birth. Their pelvis is more for better locomotion. They have a different kind of bone, pelvic bone. From the skull we can see, and from the pelvis, whether it's male or it's female. That specialization has to be taught. What if you have conflict and you end up with bodies in mass grave? We are heading into elections next year, yes? You understand what I'm saying? You know, some things you have to think, yeah? If firearms are more registered with law enforcers, then what kind of weapons does a natural population have? In countries like Burundi, they just have pangas. And this is what happened in Rwanda, right? They just people chopped each other. So what was the cause of death was sharp, blunt, what we call corta cortundente, which is a sharp edge on a blunt object that's heavy. Okay? So if you have digital forensics involved, then you're going to have examination of that digital evidence. So all these different disciplines are supposed to be interacting on one case. How do you build a governance framework and an infrastructure for that? This is what the law is attempting. Maybe we need to think about how we want this law to be. So we talked about this. Investigation, crime scene can be a place, an object, a person, a suspect, a victim. These are the kind of examples of sources of biological evidence: sweat, skin, blood, tissue, semen, earwax, vaginal cells, rectal cells. And the same applies. The same applies. Chain of custody must be maintained. It must be, we're looking at the law, the policy, the practice, the procedure. So you can appreciate, like I said, the law, the policy, the human resource, evidence management, databases. For example, we have discussions about DNA database, right? There's a DNA sex offender registry and supposed to be a database, but there is no legislation on the national there's no national DNA legislation. So then we have an issue of costing of services. Do you know how much it costs to examine a rape victim? What is the governance cost of examining a rape victim? What's the governance cost of analyzing a fingerprint? Yeah. So we talk with the issue of ethics, education, oversight, autonomy, research and development, the impact across the criminal justice system. And where you now have police police part of work that contributes to forensics, medical part of work that contributes to forensics, laboratory part of work that contributes to forensics, for the end user, which is essentially the justice system. There's a basic evidence pathway there. And this is now bringing us to our next section. So I think from here, you probably now maybe have some questions. We will look more into the scope of how wide this is. I will tell you, we have mapped at least 15 areas in the governance framework. Out of those 15 areas of the governance framework where you have general forensic topics, those 15 areas are translating to about more than 100 areas of application. So are we building a laboratory science bill
Should it be called National Laboratory Science Bill, or should it be a National Forensic Services Bill? Should it be a another fragmented law, or should it be a primary overarching, harmonizing, and standard-setting law for forensic processes across the governance framework? So I think we'll just take it from there. Thank you.
Let's give her a round of applause. Thank you, thank you. So, colleagues, it's time for refreshments. We take 15 or 10 minutes, or we do working tea. It's easier if you do working tea. Sini kweli? To negotiate. We are trying to negotiate. I'm trying to negotiate with all of us. Can we do working tea? There is a yes, there is a no. In the spirit of wellness. Okay, how many minutes do we give ourselves? Let's do 15. Let's do 15, kindly. Let's try work with 15, kindly. Let's try work with 15, kindly. Since our 11:15, we are back. Kumka kuna lunch immediately thereafter. So, don't take too much.
Tafadhali tunaweza rudi kwa meza zetu tuendelee. Because we are trying to also catch up with time. You can bring your tea to the table. Alice, you can bring your tea to the table, tafadhali.
Hello, hello. Wale hatujapata chai, you can pick your tea and come with it. Tuendelee na working session. As we see how things go. So colleagues, I want us to do a quick session of question and answer, interaction, not for more than 10 minutes. And there's no order into this. There's no order into this. The key fundamentals is whether do we now have an appreciation of what the bill is all about, what in terms of forensics is all about. That is the whole question. We were just the background so that then we are able to go into the meeting itself. So question and answer for not more than 10 minutes, and then our experts do their best to respond, and anyone in the room will also do his or her best to also respond. We all have the solutions. The solutions are with us. That's what we believe. So anyone who has a question, issue, comment, question, issue. I might be the teacher and I ask the question.
Thank you. For me, I think it's more of a comment, and I think when the presentation was made towards the end, from my end when I was looking at the bill, right now we are looking at TFGBV and how, of course, it manifests with the SGBV component and gender-based violence component. I like the recommendation, or rather the option, that we should look at all the laws that we work around, especially sexual violence, domestic gender-based violence, and whether this bill should actually be informative to reform other laws. A good example is what was mentioned, like, for example, the Computer Misuse and Cybercrimes Act. Right now, digital violence, or TFGBV, is something that is working in pieces in terms of how it's being responded to right now. And when I was looking at the bill, for me, I don't know if I've reached that stage, but I think it's more of a consideration on whether forensic science has been defined in the bill should actually focus on the examples that you have shared in terms of forensic science could also include digital forensic pathology, so that now when the law comes to place, it informs other laws in terms of how they respond. So for me, I think it's an opportunity, and it's a good opportunity that presentation was made prior, so that for us to even share some of the comments that we have on what the bill should look like, then I think that should also be presented, because from what the bill looks like, it looks a bit academic and not more practical. So I think, yes, thank you for the presentation that was made. But for me, I think one thing I think we should push is for all the things that we're discussing here to, of course, be presented to reflect in the bill, and especially with the emerging forms of violence that women and girls face, then forensic should really be amplified in a way that supports prevention and response. So thank you.
My question to Doc maybe will be, after going through that bill, now how do we link it to other acts that we have? For example, the Evidence Act. Is there any link? And also when you look at how you have taken that through, at least right now we know what is required in that forensic science bill. The one we have looks more of a policy or more of centered to the national laboratory. So I don't know how we will support and make them understand the whole concept of forensic science, because I think it focuses more on the analyst compared to the whole picture of the forensic science.
Thank you so much for the presentation. I have two questions. My focus will be on the SGBV. Is the protocol the same when it's a minor vis-a-vis an adult in terms of the process? And then number two, have you seen gaps when it comes to the forensic evidence management vis-a-vis what is being presented in court? Are there gaps that you're seeing, and what can you do about it?
Thank you for the presentation. So far, I think it has allowed us to be on the same page. One question, you mentioned that forensics is, the evidence can be pictures, can be videos, the presentations and all that. What's your expert opinion on, like, for example, the case in Utumishi? There is now discussion on privacy in dormitories and sleeping cubes and all that. Is there a line, or is there, where do they conflict? If the CCTVs were not there, we would not have videos. What is the relationship, and how can we navigate such conversations, especially when there's need for the legal process to happen? In terms of evidence and also privacy, where is the linkage? Is there one?
Good morning. Morning. My question, it's still morning, yes. My question is with regards to generally just a forensics bill. How human rights centered is it, especially in your opinion as an expert? How human rights centered is it? Because there are times when, as much as we might rely quite a lot on science, we might find that it's very condescending and paternalistic. So for instance, if I may give an example, as we're trying to retrieve evidence to prove rape, you might find that you're re-traumatizing the victim. So how would you find a balance between, actually getting the required evidence vis-a-vis the human rights of the person who's affected? Thank you.
Thank you. That was a very elaborated presentation. Mine is on issues on sexual and gender-based violence. How will the bill guarantee timely results and survivor-centered report that will lead to, accountability? Yeah, on the accountability. Thank you.
Yes, thank you. So I have really enjoyed the presentation and the analysis that you've given us. And I was thinking out loud as I've been counsel representing victims of gender violence. And one of the challenges that we had was we seem to be the ones wanting justice more than the victims sometimes. Because for me, I'm an officer of the court. For me, that justice is the ultimate goal. But you find the victim may not be on the same page with you. So I was wondering now, in terms of this bill, this law, is it able to cure the instances of storage of evidence? Because one of the things that I automatically thought at the time could help this is that the victim may not be, and I apologize to my NGO colleagues, I use the word victim intentionally. At this point, at the time that the incident has happened, the victim is not ready to confront the trauma because it's a crime that has happened inside their body. But is this bill able to cure the aspect of storage of evidence such that samples are taken and they are stored properly, in that when the victim is ready for prosecution, we can, set the ball rolling, and, the perpetrators can be brought to book? Thank you.
Okay, so thank you so much for your questions. I was hoping to hear a non-SGBV question as well, like homicide or something like that, but maybe in the next round. So the first question was regarding all the laws that touch on gender-based violence crimes and the need for forensic science, the definition to be expanded or all-inclusive and include other laws. Actually, when we were doing our research, we found that there are some areas of various aspects of forensics that are in different laws. So like the Coroner's Act talks about evidence management, right? Then there's the Forensic Science Bill that talks about evidence. Then there's the National Police Service Act that also talks about evidence. So it needs to be very clear, that has to be looked into, and I believe the legal team are the ones who go through these acts during their development to determine whether there's repetition and all that, yeah? Your statement about the bill looking academic, I think you're right in terms of, we agree that it seems a bit superficial, not really not practical. It's not telling people, this is how you move this swab from point A to B, and this is how you must write down the details on the swab, and this is how long it can stay in the hospital, and after this number of days it has to move to point B, and the lab must accept. In fact, one of the things we noted was when they talk about acceptance of samples, they just say you accept samples. That's a whole process on its own. There is a very specific step-by-step process to receiving samples at the lab, which ones to be received, which ones to be discarded, which ones to be returned, and so on. So we will go through that part of the bill a bit later, then we can discuss more. The other question was about...
Yeah, so the issue we're just trying to make sure that we are comprehensive and simple in making this understandable, is that the laws, we are forensic specialists. There has been no attempt that we are aware of to examine the legal ecosystem where it speaks to forensics. That is not a research that we know. That's why I just pointed out what I found from Strathmore. So you have this piecemeal, but in terms of looking at the whole legal and the entire ecosystem of law in this country, where forensic intervenes, that kind of study has actually not been done. And it's being done piecemeal. And the reason is you get funding for example, tech-facilitated GBV or drug-facilitated GBV, or so you end up with just these kind of different laws, but there's no attempt to actually study the intersectionality between forensics and the law in Kenya. I think the second one was...
These are all the same comment. Forensic science definition
yeah,
should be expanded. Forensic should support prevention and response. Maybe you talk about the database. forensics should support prevention and response.
For GBV.
Yeah.
Okay, so let me just say this, that what you're asking us are procedures. Isn't that? We have been asked procedural questions, right? But there is no place procedures have actually been written down. Forensic procedures to address gender-based violence or different types of crimes. The forensic SOPs in this country have not been written down, or whether they have been written down by someone but we don't have public access, we don't know. Those SOPs, and you see, SOPs come from policy, which also comes from law. We are the implementers. The forensic people will implement, whether they be police, they be doctors, they be scientists. They can speak. There is a law, but then the policy, which translates to procedure, which translates to practice, which then is regulated. This is what we don't see, and that's why you have all these questions. Is because you're asking us policy questions or procedure questions or practice questions. Okay, so we will go into the scope discussion. Yeah, so we will tell you how these other laws. Basically, the simple answer is research it. You see, we are trying to make a law. What I understand about a lawmaking process, for it to be effective, it must understand the context. Is that true? So we don't actually have a contextual analysis onto the state of forensic science in the country. We'll give you an example. One of the documents that is supposed to be shared with you on email, and this is the part where I don't agree with the green thing, because I wanted everybody to have handouts. But you will see, in the UK, they did 7 parliamentary inquiries into the state of forensic science in the country. And the table will show you, it has the year and all the questions that Parliament was asking. In our country, we have never had a parliamentary inquiry into the state of forensic science. We have also never had just independent, people coming together, funded, looking for resources to actually do this complete study. And so we actually don't understand what we are creating the law, the policy, the procedure, and the practice for. As specialists, we can reverse engineer our way back as specialists, but we also can't do it alone. Because this is a law enforcement issue, it's an oversight parliamentary issue, it's a treasury financing issue, it's a healthcare issue, it's a mortuary issue, it's a family issue, it's communities issue. So the simple answer is we have to research it. There has to be a policy justification for this bill. As a specialist, I'm like, it's a no-brainer, yeah, let's have a bill. Let's look at, we can now debate whether we do it just for the labs, for forensic labs, or we do it for the full scope of forensic services that the Kenyan population need, that's relevant to the criminal justice system. The policy justification has not been carried out, and that's why it is hard to make a proper law in terms of lawmaking process for what this bill should actually be addressing. So I hope I've answered that question.
Yes, you did. Thank you very much. The third question, is the protocol the same in minors versus adults? Assuming you mean protocol in terms of forensic examinations. For minors and adults, it's different. There are actually national guidelines for both. There's the child sexual violence SOPs. There's national guidelines on management of sexual violence. There's also a training manual on the forensic module that trains medics on how to gather evidence. That's a very long discussion. I would rather maybe see you behind the tent because there are so many factors, yeah? Then, have you seen gaps in the management of evidence that is presented in court?
So back to the same issue, the research, right? Yes, as specialists, we have noted gaps. Maybe you want to write this down. Write down forensic observations and recommendations on sexual violence in Kenya. If you can Google it, there's a whole PDF. That report actually was featured in something called SDG 5 RELX. That paper was downloaded more than 4,000 times a few years ago in 2019. Kizzy and I don't know the status now. But we actually pointed out to the gaps of the forensic gaps in terms of sexual and gender-based violence in Kenya. So that could help you know our thoughts. Even back then, those things we have said still stand today. Yeah. We just keep reinforcing. Yes, we have noted gaps, and in that paper, we show the imbalanced approach and the fragmented approach towards the management of sexual and gender-based violence, but we also produce something called a model, which is a multi-agency assault management center model. So we don't call ourselves proponents of polycare or SGBV recovery centers, or for us as specialists, we understand we are dealing with levels of assault, categories of assault. And yes, there are law definitions about all this, but as specialists in forensic medicine, that multi-agency assault management now actually puts the forensic procedure and practice and what would be the forensic best policy on how to address those cases in order to seal gaps. So it might be helpful. We can also talk about it some more beyond what we have for today.
Yeah, but in summary, you have issues now with like community level evidence management. You know, when people, if there's been an incident, they burn clothes, they throw clothes and all that, if they don't have the right guidance. Then you have, like at the medical sector, I think we've highlighted the lack of knowledge is, you know, there's an assumption that our universities teach all our medics, nurses, clinical officers forensic evidence. The truth is, this is not taught. You have to look for it and go to those countries to learn about it, come back, figure out how to practice it. It's actually a very strenuous process, right? But it's not taught to everyone. So if you don't know, then it will be difficult. So that's a huge problem, because many victims will actually get to the medical facility, but now what happens to the evidence? And even to respond to the question on evidence storage, a lot, because we don't have laws and protocols on evidence storage at medical facilities. Everyone does what they want. We only keep for 5 days, then we throw. I remember the first time I heard that, I was so shocked. You throw away evidence? How? This person will, you know, we have now thrown away her chance at justice. You know, you never know how it could have gone. Others will keep for 2 weeks and discard it. Others will keep for a month. That is a huge problem as far as evidence management is concerned. So it's not captured in the law, and that's something the forensic bill should be telling us. In our country, we will keep, the police will pick kits from the medical facility and store them in storage area A in town or somewhere for an X number of years or months, you know, in case there's a cold case. So, yeah, and then of course, when it comes to providing evidence in court, again, you have to have the knowledge. What does a yellow bruise mean? What does a blue bruise mean? What does an abrasion mean? What does this mean? How is the genital different in a 2-year-old versus a 10-year-old versus a 20-year-old versus a woman with children? What does it mean? When you don't see injuries, what does it mean? So this is something that we constantly have to read about. Every year we are looking for new information regarding injury interpretation, what the global experts have agreed on, and so on and so forth. So that's about evidence. Like Mirna said, please check that document. Now, evidence can be The next one, evidence can be in pictures, videos, etc. What's your opinion on the case at Utumishi regarding privacy? Should you have CCTV in the dorms or not? I think that is, I don't know if we should attempt to answer that in this session or in this forum, because it's a very social, legal kind of question, policy question, and not really a forensic science question. However, the CCTV footage provided a lot of evidence, and it was very helpful to getting the perpetrators. Number 5, how human rights, is human rights factored into the bill? Your question was about re-traumatization of victims. I think we had mentioned that if you use a trauma-informed approach, it's all about your approach towards survivors. I have never had a survivor not accept to be examined, and I've seen thousands. Doesn't matter if they're 1 year old, 3, 30, as long as you explain. Actually, a lot of our training is on how do you approach people, how do you speak to communities where there's been death like Utumishi. There's supposed to be a protocol for that. So even with survivors, if you just explain nicely and you have your correct body language, there's a solid environment, it's giving the right kind of safety requirements, it shouldn't be a problem. But if they do not want to have it done, you just let it go and you don't keep pushing and insisting. You capture what can be captured with consent. The last one. Oh, yeah.
So whether the bill is human rights centric, we haven't seen language that is indicative of that. I guess it's silent because it's somehow assumed that forensic science governs how forensic evidence is managed. But I wouldn't say that it's human rights centered. I would say it's laboratory centric. It's regulatory centric. It's licensing centric. It's chemical weapons centric, and chemical weapons is relying on essentially one discipline, which is forensic chemistry. Rather than you have forensic biology, you have latent print examination, you have document examination. So it's actually a whole big chunk of the bill is about chemical weapons legislation riding on on forensic chemistry. So the bill doesn't come out to explicitly say these are the timeliness of evidence management. That's actually should be in a biological evidence preservation like toolkit or procedure that we write out. But I think the way the bill is structured, it was very, like Dr. Ari said, it's very surface. And it can end up curtailing stuff instead of now allowing a more inclusive conversation about the areas of scope. So let's just go into this, So I think we will, for now. So this is essentially, the bill is structured like this. It talks about forensic science as the title, but chemical weapons is piggybacking on this bill, so that it's assented into law. So these are two issues. We're actually saying delink these two issues. Chemical weapons is in its own right. Kenya ratified the Convention on Chemical Weapons between, I think, I'll need to check the years, but it's been long overdue. So these two matters are long overdue, but they need to be delinked from one another so that they follow two distinct legislative pathways. I also don't think it's fair for chemical weapons to continue. We've looked through the discussion on chemical weapons. It seems very straightforward. But this forensic science part is the part that's not straightforward, or it seems like it's not inclusive. We have two issues in the forensic science part. Are we dealing with laboratory services, and what are those? And are we dealing with the full scope of forensic sciences for the population of this country? The laboratories forensics part is also introducing an issue of regulation. So it automatically goes into a board that they shall be a National Forensic Science Regulatory Board. That is a very huge term because it implies that you have practitioners and you have specialists. And these specialists are well known, their skills are well known, their qualifications are well known. So you have an attempt to regulate here, and regulation should be, this is forensic best practice. So, so we are saying there has to be such a high level of scientists sitting at this, at some stage here. And you can have an administrative part of regulation. But what has happened is that we don't know, the board is right now administrative and without scientific best practice. It's not clear. What happens in a normal setting or an ideal setting is that you have a forensic association, because you have a forensic field, so you have contributors from the field, specialists, into the forensic association. From the forensic association, you form what are called best practice working groups. So the way in law you would have, you know, someone who is very good at commercial law, someone who's good at maritime law, someone who's very good at intellectual property law. So you have all these different disciplines. So you have the best practice working groups. So you would contribute representatives to those, you'd segregate the forensic association into best practice working groups. The best practice working groups will then present representatives of fingerprint analysis, of DNA analysis, of arson investigation into explosions. You know, so you have these key people, right? You have people here, and now these people would represent what are called your best practice scientific board. Now, when you have this best practice scientific board, it is expected that these are the best people that you have as single representatives, even if you were to say, so you'd have about maybe 15, 20 practitioners sitting in this best practice scientific board who already understand the fundamentals of ISO standardization of forensic processes. And these people then would then report to a somewhat administrative arrangement. And that, in most countries, you will find that they report to parliament in kind of like an ideal setting. So this is, but currently the law does not, as currently constituted, the inspector, the PS of internal security is the chair, is basically chairing this regulatory board, of which you just don't have the structure. So you have two representatives from what they're saying is a forensic association, which in Kenya I checked, and it's basically cybersecurity as an association, but cybersecurity, digital forensics is only one part of the whole scope of forensic sciences. And you have one person from a university. And we have never, there's been no evaluation to actually know whether these universities actually teach the proper standard of forensic science. We have never had an evaluation of a course, so we don't know. And actually you might tell us there is, but the reality is if we are taxpayers, then this information needs to be accessible and it needs to be publicly reviewable. So you have, so we have this issue we talked about, which is now regulation, and the issue of licensing. So there's an attempt now to license forensic laboratories. So I don't know, Dr. and I are joking. Maybe we should open a fingerprint lab. As medical people, we should then just open a fingerprint lab, right? And just find a fingerprint guy and just do fingerprints. And if you don't pay our bills, we're not coming to court. Our guy is not coming to court to testify, right? If we end up with pending bills. So we have so this is likely to go very unethical, if not properly written down or debated and drafted, researched and drafted. Then we also have this. So the regulator wants to license forensic laboratories. So it doesn't say that there will be private forensic labs. It's quiet. And so the regulator wants to regulate the DCI, National Forensic Lab, and the Government Chemist Lab, which are all Ministry of Interior, and the regulator will be basically chairing the regulatory board. So in a nutshell, this is kinda how things look, but let me move from here and go to the presentation. I hope we are just trying to reinforce, make it simple, kind of slow, but so that you get it. So in our preamble, this is how we started. We noticed that the bill has two parts, mainly two components, which is forensic science and the prohibition of chemical weapons. We are saying these are essential, they are necessary components for lawmaking process. We agree they are long overdue. We welcome them and we say that they are timely. However, we propose that both aspects of forensic science and the prohibition of chemical weapons be delinked from one another and follow two distinct, mutually reinforcing legislative development pathways to provide maximal benefit for the people of Kenya. So it's mutually reinforcing because, yes, there's a part of chemical weapons investigation which needs forensic chemistry, but gender-based violence needs forensic biology, right? Corruption needs forensic accounting audits, right? It needs forensic accounting. If you open your phone via biometrics, the biometric sciences are forensic sciences. You know, like if you open your phone with facial ID, does Apple have a right to give that information to someone else? Does it have the right to give it to your government? Like, what in terms of, can that be used as evidence against you? I mean, so we are saying that delink these two parts. We are saying that we have actually the issue and why this is happening, like why would someone do that? One is we have realized that forensic science and related legal frameworks have followed a discernible pattern characterized by fragmentation and uneven development. So the pattern of dysfunction has been shaped by donor-driven mutual interest, okay? Lack of research and development in key areas. You have outside-in resource mobilization. If I'm a donor, I want to talk about HIV, we talk about HIV. I'm giving you my money, right? I don't want to talk about maybe HIV, and I talk about HIV even in PWDs, but I'm not going to talk about PWDs outside of HIV, right? And PWD's issue can be is bigger than just HIV, right? I'm just giving that as an example. Prioritization of specific thematic areas at the expense of leaving others behind. How was our child protection unit in the police formed? How was our counterterrorism unit formed? You know, if I'm a government that's interested in, for example, keeping my country safe, and I say I need to develop systems that can outsource prosecution of certain types of crime, then I'm going to create systems, forensic systems, to generate evidence from those types of crimes, which I need outsourced. Then you have science-based work is hardly domestically funded. How much of science and technology of our research goes into, how much budget is that? There's actually one person on the regulatory board from science and technology, and we're just like, if that person is not the most senior forensic specialist in this country, what would they be offering to the board? So the problem has been we have championed advocacy, even in issues of gender-based violence, over accountability. The outcome of this dysfunction, like we have said, you end up with selective development, acceleration, and consolidation of certain forensic disciplines. So we have a lot of funding for forensics that has gone to build forensics for counterterrorism, and in different countries, even in the region. And forensics for sexual and gender-based violence is not even a paper that has ever been researched. Yeah, forensic evidence in the forensic ecosystem and how it addresses sexual and gender-based violence has never been done, right? We just did some related work the other day, but we have not, such a paper has never been published. Investigation of death investigation. It took a lot of time before the National Coroner Service Act came to draft to publication. Deaths of migrant workers, management of missing persons. There's no law on a national missing persons database. So we have bodies in the mortuary. We've had them for over years. Bodies in the mortuary, unidentified persons, unclaimed bodies, but no law on missing persons. What the Evidence Act is saying in Section 118 is that you have to be missing for more than 7 years to be declared a missing person. That's it in law. So that's why we are saying that, like as forensic specialists, we need to now sit in a room with legal people and law enforcement and literally like kink out all these things: law, policy, procedure, practice. Identification of human remains, torture, injury examination, like forensic, like I said, you know, that forensic photographic approved device. Every patient should be having an SD card. They should. So sometimes I think we need to have that conversation to break it down in terms of equipment, in terms of financing, in terms of education. So all this is, the outcome of the dysfunction is we are inadequately researched, undeveloped, unregulated, and many times disregarded, but it's a knowledge problem. The impact is that the ecosystem in Kenya for forensics has evolved without a primary overarching unifying, that is harmonizing and standard setting legislative framework. Laws, policies, practice, procedure, practice, and regulation of the field governing various types of forensic evidence. So we have inadequate laws, lack of corresponding policies, lack of harmonization of those laws, challenges in implementation. Actually, for long after the Sexual Offences Act was published, I mean, policy has taken so long, right? In fact, now the response part is the forensic part, if you want access to justice. Isolated pockets of growth that struggle with coordination and then enablement of unethical practice. So we are saying, is this what we want to do with this forensic service bill? Because this forensic bill does not speak to the full scope of forensic services. It does not. So the full scope of forensic services, so what should we be aiming for? If we are aiming for something that is nationwide, helpful, practical, will help to harmonize various forensic laws, would be to say this law should look at the forensic scope. So it should acknowledge the full scope of forensic science disciplines, their corresponding areas of application, the relevant forensic examinations based on valid scientific methods of analysis. So for example, in this country, we don't do hair analysis, right? And we could have, and identifying certain types of drug via hair analysis is something that is done, but not in our country because it's not available. Am I right, Kizzy? The last we checked. So all these four, the way I've just said them, the bill needs to, if it's going to be a full scope, legislation, it needs to look at that. It then needs to look at the forensic evidence life cycle. What we said, crime scene to courtroom. Remember the 7 steps? Yeah. The forensic procedures, how we categorize procedures, how we discuss consent, how we discuss orders for collection of samples, how we talk about in terms of expounding evidentiary admissibility. Is that a requirement? Are we okay? Forensic databases. What kind of databases should this law speak to? Should it speak to a national fingerprint database, which is civil, which is criminal? What happens to telecommunication companies and hospitals that now are collecting biometric fingerprint data? What happens with the data at immigration, at police? What about a national DNA database? What about a missing persons database? What about the ballistics database? If someone goes out with a gun, there's a riot, they are shooting in the air, we have our dead child, right? What are the laws on the ballistics database where it concerns civil issuance of firearms or registration, and the same for law enforcement? What about forensic information management system? If a rape sample today is collected in a hospital, a sample relating to a case of rape, then should it have continuity in the system? Should it be barcoded and tracked across the various stakeholders? Also, officially certified experts. For years we've been saying Kenya should have a gazetted list of forensic experts, but we've just been saying it, right? So what is the legal status of officially certified experts? Are they from the state? What about non-state? Like recently I was called to testify on the issue of Shakahola, right? So I can go there and we talk about my credentials, but at the end of the day, the state, we should actually be able to say in this discipline, we recognize this person's qualifications, their experience to speak on the subject. Forensic institutions, legal status of forensic institutions, the state and non-state. At the moment, the bill is what we would say attempting to ground the government chemist lab, ground the National Forensic Laboratory. I wrote their combined expertise. Now I can't remember why. Okay, I'll remember. Forensic quality management. Oh, sorry, combined expertise. What I meant was the law is saying that we should, that it will register forensic labs, right? So are we saying we are ready for private labs? I mean, it's a big question, right? Or what we think we should do is keep state-run laboratories, but make them independent, impartial, objective, neutral, scientific. There's no interest in whose gun that was. If that's the gun that discharged that, if that is the gun that was involved in the discharge of that bullet, it doesn't matter whether it's your friend or not your friend, or, you know, you cannot weaponize the system, right? So we need to think about that. Forensic quality management, the ISO standardization and accreditation of personnel and institutions, and even forensic educational institutions. There's so many mushrooming institutions in forensics, and a very limited marketplace for those skills. Also, we don't know what education these people have been taught, so we can't vouch for anybody. Financing of forensic examinations, how much, like I said, how much does it cost? Because as a state office, let's say I'm the national coroner, I work in the national coroner's office, and there's a body to be done post-mortem, okay? The state should say, what is the actual cost of that post-mortem? Is it 10,000 shillings? To the state, because it's the state's responsibility to investigate crime, the post-mortem is free. But is it 10,000 shillings? Is it 20,000? Is it 80,000 shillings? Is it costed? Will every post-mortem have a CT scan? If every post-mortem is going to have a CT scan, how much does the state, how much does the National Coroner's Office charge Ministry of Treasury, Finance, Planning for that postmortem, right? So that in a year you know that I do about 3,000 postmortems in the country. Each postmortem is at 52,000 shillings or whatever, and the cost is this amount of money, 100 and something whatever million, okay? That is, and I think this is the reason why we have a big problem with corruption, is because we just haven't budgeted these things. We just procedurally don't know how to charge one another. And then, you know, the National Coroner Service Act issues an e-teams, or whoever issues an e-teams to whoever, right? Then the equipment and the human resources, like I showed you that ruler. The sexual offense, even the buccal swab that we used to collect samples from the suspects, who gives who that equipment? Where does it come from? Is it manufactured here? Is it imported? And then forensic coordination, mechanisms across sectors. How do these offices relate to one another? And then this entire regulation. So the regulation of forensic science, if you're putting yourself in a regulator position, it means you're saying you're the custodian of the field. How can you be custodian of a field that you don't understand? You've got to understand A, B, C, D to Z of the field. The basics, number 1 to 10 of the field. Yeah? Alpha, beta, sigma. You know, you got to know the basics of the field before you put yourself in a regulator position, because the regulator, the scientific best practice person, is going to stand in the position of forensic science regulator to establish a code of practice and to publish that code that the state institution for forensics and the private lab will still have to follow the same standard. They will do investigations. Did you analyze the fingerprint correctly? What happens when there's an appeal? The regulator, in the current draft law, the regulator is the same person you go back to for appeal. I mean, the way they have said basically that they make the decision and they review the appeal, okay? So there's no independent tribunal in that, in the draft. So compliance checks, receiving appeals, that's the part of a regulator. And it's very important you read the documents that you will be sent, because an example is that in 2021, the UK government, after doing the 7 inquiries into the state of forensic science in their country, which is a research, was like, we're going to establish a separate office of the regulator. They wound down their forensic science service as a government, and now they just do they have a separate act for the regulator. So what are we saying? We're saying that we need to borrow from what is ethical practice. We need to champion the forensic best practice, the scientific best practice. For us to say that we are going to adhere to the right to a fair trial, the right to a fair trial means that the science, which this bill is talking about, national forensic science, the science is objective, it is neutral, and that whoever is regulator, service provider is impartial. So these are the ISO standards. ISO standard for forensic science defines standardized forensic terminology. Does the Act do that today? We just see definitions. We may not necessarily agree with them, but us as scientists have not sat in the room with other scientists. All scientists have not sat together. We have just received a document, right? It should standardize forensic terminology. Create a common language for practitioners, laboratories, investigators, and courts. Remember, investigators are police, they are doctors, right? Anyone doing a forensic investigation into a crime or human rights violation, whether it's finding drugs, okay? There's also this idea that the Government Chemist Lab, which has been doing investigation into water analysis, food, yeah? So you have, this bill, it's like a bill created so that an institution and people can have some level of career progression. So I'm not sure, should you have a lab in a hospital, you have a lab at KEBS, you know, who should handle what? And when you say analytical labs, what happens to labs like, you know, toxicology labs being run by medical people? But Daktari will speak to this. Recognition, recording, collection, transport, storage, what we talked about, like the 7 steps: identify, document, collected, transported, stored, preserve, maintain the chain of custody. All this, the analysis establishes requirements for forensic examination and testing, emphasizes validated methods, competent personnel, quality controls, and appropriate analytical strategies. The interpretation of that evidence, that is, provides guidance on evaluating and interpreting forensic findings, and then reporting it. That is the international forensic science standard. Does the bill speak to the standard? We have found that it is wanting. It is more administrative rather than speaking to the standard. And that standard should generally apply to the whole forensic science field. We have other standards here, so 17025, requirements for competence, impartiality, consistent operation of testing and calibration in labs, so that the labs produce valid, reliable, technically competent results that are internationally recognized. This issue of impartiality, we're saying that law enforcement should separate itself from the issue of trying to control the lab. You can be a client of the lab. IPOA can be a client, DCI can be a client. You can be a client of the lab, but you are not the owner of the lab. Yes, that impartiality is very key. 17020 specifies the requirements for competence, impartiality, and consistent operation of inspection bodies. So, who is going to accredit forensic science in Kenya? Is it KENAS? Who is it? Is it the international bodies of accreditation in a country like ours where public trust and confidence is really low? These are things that we must examine. So the scope, like we said, is huge. Biometric identification and identity management. In the documents that you will be sent on email, these 15 become around 124 areas of application. Actually, we will try and open for you. Crime scene investigation and evidence recovery is some sections. Forensic lab sciences, certain sections. Medical, legal, and clinical forensic medicine, services for the living, services for the dead, mortuary, funeral, disaster forensics, exhumation, forensic archaeology, forensic anthropology, cemeteries, forensic psychology and behavioral sciences, the ability to be fit to stand trial, digital and cyber forensics, question documents, financial records, environmental forensics, wildlife forensics, agricultural forensics, transport and industrial forensics. I don't know if you saw that video of someone who was on the expressway and hit the other vehicle. I mean, you have potential there, you have CCTV evidence, right? So you have digital evidence. But you also have potentially, was that person drunk, driving under the influence? Right? So we have a forensic toxicology, which is a blood alcohol analysis. So you have then, if you have this guy, there was this lawyer who was shot inside a car, yeah? So you'll examine the vehicle, you'll examine the body, you're into ballistics because he was shot, right? Then you have special populations. What do you do with children who are in borstal institutions, people who are in mental asylums, people who are in prison in the state, women who are maybe or men who are being sodomized and raped in prisons? Is that part of, some people joke about it, but it's a very serious problem. Yeah. Then missing persons and humanitarian forensics. how do you bring closure to families of missing people? Forensic, and now you have the situation with all these missing children, right? Forensic information management and quality system, forensic reporting, governance, capacity building, forensic education. You will see that this classification breaks down to, and different countries have different way they classify all this. But forensic science, when you say forensic science governance, this is what the law will be attempting. Even if it's quiet about it, at some point you will start to see, no, but we own that, but we are the ones who are supposed to do this. So can we have it in the open and see what areas and how to define the terminology of the law? So the research, we are saying this law is not ready. We're just saying you're not ready. Go back to the drawing board. You're not ready. And being ready doesn't mean it's just forensic people. Being ready means it's forensic people, it's law people, it's law enforcement people, it's parliament oversight people, it's the Justice and Legal Affairs Committee, it's the Committee on Internal Security, it's military forensics. Yeah, military forensics is another space, right? It's what happens to the families of people who went to Russia. You get what I'm saying? Like, what happens to the deaths of migrant workers? So this is by far the biggest, probably the biggest impacting law on all those spaces of daily life that I spoke to. So a research basis, so what we are saying is this law must be preceded or accompanied by a comprehensive, independent, publicly accessible assessment of the entire forensic ecosystem in Kenya to develop a legislation that is fit for purpose, effective, and aligned with constitutional and scientific standards. We are not going to negotiate on the science. You surrender. Science wins, okay? We will not negotiate. As the scientists, proponents of best practice, we will not surrender. We would rather stand today and say, it is not ready, we are not surrendering. What we should have is a proper inclusive dialogue where we sit down and actually define the terminology for the law draft, make sure the lawmaking process is correct, proper, and reflective of our context. And then we have another question. We're saying this field is so highly technical. Reviewing this law for us is technical. Can you say if it's not been adequately researched and is not well understood and it's not been simply explained, then can this law be even said to be public participation ready? And then what is the threshold for public participation? Is it so low that tomorrow we can just go somewhere, talk about aeronautical engineering? If I don't even understand aero means in the air, like I could just say yes or no, and that's public participation. Is it supposed to be meaningful? And so if it's meaningful, then what does that mean? So we are proposing that this matter, chemical weapons can probably go ahead. We don't have an issue with that part of the draft. We have an issue with the forensics part of the draft because the drafters of it need to come out very clearly to say, is this a forensic laboratory bill or is this a full scope forensic services bill for the people of Kenya? So we are saying halt this matter. And I don't know, apparently Parliament can commission an inquiry. Yes, it can. So it should. It can. So if it can, it should. So we are saying what would be the summary of terms of reference for such a research is map the country's forensic science capabilities, understand the areas of application of forensic science services available, the caseload, the quality of the same, a comprehensive understanding of the intersectionality between the current legal ecosystem, what laws are currently existing for forensic sciences, what parts of the areas of application does that law speak to, those laws speak to, and how does the law need to be reformed, or what needs to be changed in order to bring harmony. Because the reason we are struggling with implementation of even issues to do with sexual and gender-based violence, or you can do so much work in a field but you will find barriers because the intersectionality between the legal ecosystem, forensics, human rights, and law enforcement has not really been well researched and known. Identify challenges in the field of forensic science and its application to various matters across state and non-state stakeholders. Identify the gaps in the proper management of forensic evidence cycle across the stakeholder institutions. Develop a roadmap for the way forward by providing recommendations so that this draft legislation is evidence-based, it's data-driven, and customized. This is a great opportunity that we have been presented with in terms of this draft. We're just saying, clarify what this draft is actually for. Because if we have all this crime, human rights violations, we have all this caseload, we would like the law to function in such a way that when you release the SOJA report, that we know in how many cases was forensic evidence of good quality actually used to convict cases, right? To bring about convictions. So it should be, the coordination requirements are immense. And so it's not a matter that needs to be taken lightly. This idea to have a regulatory board, I think, was just premature as far as the context is concerned. We are not saying regulation is premature. We're just saying, as far as our context is concerned, the way in which we approach regulation, we haven't even researched it. What are we regulating what we haven't even researched? How are we regulating what we don't even know? So the administrative board in the document is not a scientific best practice technical forensic board which can establish standards. It actually says that it will establish standards. It's the regulator that establishes standards, yes, but at this point we are saying this is not capable of happening. And I will explain, let me just move front, then I can move back. The reason is, and I know it's very tiny, but if you go open Code of Practice Forensic Science Regulator of the UK, even on your laptop, you will see that there are so many. This is what the board is saying that they will do. They will establish standards, forensic science standards on speech and audio analysis. They will establish standards on toxicology and alcohol technical calculations. They will establish standards on collision investigation, examination of fire debris. They're going to establish standards on okay, there's lots of standards. You see all this FSA, all these are all standards. Without that best practice, without these people, without these scientists, without these people, you don't have these standards. And you need this, because these standards have to be given to someone administrative. So we are saying they're administrative, but they're not, they're incapable of setting those standards. Because it says 2 people from a forensic association, which we know is the cybersecurity one. And we know, and so even if it's them, they can't set standards for fire and explosions. Can't set standards for forensic medical examinations for gender-based violence. So this board is chaired by the PS of Internal Security, and the 2 forensic labs, Government Chemist Lab and the DCI National Forensic Lab, are hosted under the PS of Internal Security, under the ministry, which is under the PS. The forensic service provider, therefore, is in the same ministry, under the same PS. The forensic guide for the development of forensic science labs and standards is under the same PS. The registration and licensing of the labs is under the same PS, and the regulation of the science is under the same PS. We're saying you can be forensic service providers as laboratories, forensic labs, but the guidance and the regulation and the registration and the licensing of this needs to be done by the regulator. It's the regulator who will do it. And tomorrow the regulator could be like, oh, Dr. Mirna, yes. You're a forensic odontologist. Yes, I am. Dr. Kizzy, you're a forensic medical specialist. Yes, I am. But you want to open a fingerprint lab? Yes, we do. Okay. I mean, that should be already a contradiction. You understand what we're saying? Yeah. So we have a problem with this because this doesn't speak to the issue of impartiality. So this is the UK Regulators Act. So it's an act to make provision for the appointment of the forensic science regulator, to make provision about the regulator and about the regulation of forensic science and for connected purposes. It's a very short document. It's about 6 pages. But it's very simple, very clear to understand. From this, the regulator now goes and develops all the policy, the standards, which are the procedures part, which is the proper management of evidence part, which now when you have those 1 to 7, crime scene to courtroom is in the mandate and the custody of the regulator. So there are some examples, governance model examples. So what I'll do is let me exit here so that we can show you some. It's okay, let me. So let's go to one moment. Okay, we can open. Yeah. So let's look at some examples. Example of law enforcement. So Germany has a law enforcement part of a lab. So some parts of forensic sciences are under law enforcement. Its medical legal part is in a different institution. So you have countries like that, they can have a crime lab, which is a police-run lab, and then you have an Institute of Legal Medicine. Example of an outsourced model. The UK closed its forensic science service. So it's like saying how we have a national forensic science service as a country, but they decided to close it and they rely on commercialized and highly regulated market of independent providers. So everybody is now subject to the same standard. I'm the regulator, fingerprints are analyzed like this. Environmental crime is analyzed like this. This is the procedure, you're qualified for it. Every 4 months you do an exam, proficiency examinations, audits to ensure that your lab and you are capable, so that when you go to testify in a court of law, nobody is essentially, they will check whether you are qualified to be able to give that testimony, but they have standardized their services. Examples of a mixed model. Canada relies on a mix of independent, civilian-led, provincial, and national labs. So you have, and utilized heavily by both civil and criminal defense teams. The United States has some crime labs, state labs closely aligned with police departments, but the US has a massive network of independent providers, private practices, civilian operated institutions. I mean, with this situation also means that, we are confronted with, are we ready for that jump? And are we also ready for things to be unethical, for corruption? Because I can tell you before, even if Kizzy and I could, by the time we get it, you'll be, what am I saying? I'm just saying that even if you are in the field, you want to do what is ethical and right, you understand your limitations, you don't want to have scope creep. Even if you want to do what is right, you will find others who are not even qualified to do what is that basic minimum, just surpassing you to do the absolute unethical. Okay. I don't know, where is it? Okay. So that's what I'm trying to get at. Australia. Oh yeah. Okay. So you have an example here: the Houston Forensic Science Center, independent of the police department. Many of the laboratories are certified by standards boards like the ANSI National Accreditation Board. In Australia, states and territories maintain government-run but police-independent forensic science centers. So that separation, that you don't control the outcome, you're not partial, yeah, is that issue of the separation of how law enforcement is still a service, can be a service provider, but are separated. No, sorry. They're a client of the lab. So they just come, you give me your sample, we receive the sample, and then we process the sample, and here you are. But you don't come to your own lab, right? The police does not go to a police lab. I think in a country like ours, that separation is very important. Examples of Ministry of Justice model, Rwanda has done this. So the Rwanda Forensics Institute is essentially a scientific institute for forensics, is supervised by the Ministry of Justice, which operates an autonomous public institution and works alongside other institutions such as the Rwandan Investigation Bureau. So it would mean that if we wanted that kind of model, then we are saying we have a National Forensic Institute in Kenya, yeah, the Kenya National Forensic Institute. But this is the problem we have discovered. Many of the documents which relate to our field say Ministry of Justice. Even the National Coroner Service says Ministry of Justice. And we are trying to ensure that we have that separation. So how does that separation happen? Is it possible to have an independent institution that reports directly to the committees of parliament? So you have an autonomous public institution, so you work alongside with the investigators, investigative bureaus, the hospitals, but the lab, the institute, is autonomous. So it says there, the Rwandan, on that case of Rwanda, it places an emphasis of forensics as an objective tool for the courts rather than a branch of law enforcement. The Netherlands Forensic Institute also is an autonomous agency under the Dutch Ministry of Justice and Security, structurally insulated from the police forces. Portugal, the National Institute of Legal Medicine and Forensic Sciences, it's all together, the Legal Medicine and Forensic Sciences part, is a public institute managed directly under the Portuguese Ministry of Justice. Taiwan, the Institute of Forensic Medicine, operates explicitly under the Taiwanese Ministry of Justice, managing independent toxicology and biological lab analysis. Kyrgyzstan, the State Forensic Center, is structurally organized as an independent body under the Kyrgyz Ministry of Justice to bolster neutrality of crime evidence. So I think the issue here is, how are we going to ensure, are we interested in impartiality? Are we interested in objectivity? Or are we interested in maintaining the status quo? Are we interested in not doing the research that tells us what the contextual analysis is for how this law can be properly formed? I said I'll show you the scope. So let's go to the magnitude of scope. So here we go, this is the scope. You can see we started biometric identification and identity management. We have 7 parts under that. These are all forensic areas of application. Biometric data collection and identity management systems, national registration and immigration identity systems, fingerprint identification. When you go for a police certificate of good conduct and they collect your fingerprints, that's fingerprint evidence, right? Without it, you cannot get this police clearance. But in terms of evidence retention, how long should your fingerprints be kept in the system? Are they kept in a civil database? If you become a criminal and they move to the criminal database, you know, like how long should that evidence be there? Should it be there for 30 years? Should it be there indefinitely? When is evidence retained, and when, for how long, after how long should evidence be disposed? Facial recognition and biometric comparison systems, like we see, you know, videos where presentations are being made about how we are all entering a digital world and everything is being checked and every phone call is being checked and your data and your privacy and, you know, I think that whole conversation, forensics is not delinked from the conversation on privacy, from the conversation on biometric sciences, which are actually forensic sciences. DNA identification services and national DNA databases. If we have a national DNA database, we need a legislation for it. If I come after you on a Friday, should I be collecting your DNA then? You know, like if it's like a frivolous, like, or you're just collected as part of, you know, like, end up not being, there's no threshold to charge you, would your DNA stay in the database? Because this presents the problem of procurement fantasies and realizations. In the Western world, what happens is you have what are called rapid DNA machines at police stations. So in 90 minutes, you have a DNA profile. So is that the extent to which we want to operate, and what will be the ethical safeguards for operating such a system? And also the value of having people who are convicted of crimes like sexual violence, or people who do property break into people's houses and their DNA is collected from those crime scenes, enter into the DNA database. If they commit another crime, they will be found. So it's an issue of balancing, and it's an issue of speaking to these things in law. Civil identity verification, authentication services, migration and border identity. So it just depends on how you describe all this. This can be 7, they can be 3, they can be 5, they can be 9. Crime scene investigation and recovery. We are saying investigation of locations, objects, living persons, deceased persons, suspects, victims, scene documentation, mapping and reconstruction, evidence identification, the 7 steps, latent fingerprint analysis, that is fingerprints, fire and explosions, arson investigations, firearms, ballistics, tool marks, impression analysis, trace evidence analysis of glass, fiber, soil, hair, paint, CCTV, audiovisual and surveillance analysis, digital crime reconstruction, forensic lab services. Now here we are. When we say the bill is national forensic science, if it's a lab, we're saying, okay, forensic biology, bodily fluids, DNA profiling, and genetic analysis, forensic chemistry. So here we are, number 19, forensic chemistry, trace chemicals, explosive residues. The bill focuses on this through the prohibition of chemical weapons. But what has happened to all the others that are not part of that? Drug analysis and narcotics identification, toxicology. We're talking about poisons, alcohols, pharmaceuticals. So there we have pharmacological forensic analysis, food and water forensic analysis, environmental chemical analysis, medical, legal, and clinical medicine and services for the living. Like we said, this is not in the National Coroner Service Act. And it's also not in the laboratory bill. And these are all your SGBV cases, all the torture cases, all the custodial medicine cases. Okay. All the traffic medicine, such as driving under the influence. So all the clinical forensic examinations, medical legal assessments, SGBV, torture, ill treatment, documentation and interpretation of injuries, evidence collection, biological, trace, photography of injuries, forensic odontology, age assessment, injury assessment, forensic human identification, forensic radiology, forensic psychiatry, mental status assessments, review of suspected medical malpractice, custodial forensic medicine, police cells, psychiatric facilities, Boston institutions. That's not under the Act. And remember, all this is all generating forensic evidence. Services for deceased persons. Now you have the National Coroner Service Act, but does it actually speak to forensic pathology, forensic radiology, forensic odontology, forensic entomology, clinical reconstruction of injury to death, investigation of SGBV in deceased persons, investigation of femicide, death certification, medical legal reporting? That now has to be checked. You actually have to do a legal forensic check. Mortuary and funeral forensics, you have all that. Exhumation, cemetery, this is now Shakahola, where you are, these are your specific procedures for that. If these procedures didn't happen, then what did you really do the job, the investigation, and generate the evidence for the court? Forensic psychology and behavioral sciences, digital and cyber forensics, mobile phone forensics, network and cloud forensics, video authentication and enhancement forensics, metadata and digital reconstruction analysis, question documents, financial and economic forensics, wildlife crimes, wildlife and environmental crimes, transport and industrial forensics, special population forensics, missing persons forensics, forensic information management and quality systems, all these different databases, chain of custody tracking systems, forensic quality assurance systems. So you see now when we hit here, we start now saying, yeah, all these, because they are fundamentally about evidence management and quality assurance, apply to the prohibition of chemical weapons. But we have left out everything else. Too hopeful, we'll create another fragmented law, or someone else will follow that agenda. Yeah? So you have there 124 of them. Even if you try to collapse them and say we'll merge this and we'll merge that, and for our country it's like this or that, you're looking at minimum 15 fields, and even, let's say, even 100 or even 80 of these areas of application. But because we don't have a research that actually tells us how many of these 124 are relevant, who's doing them, what's the quality of that evidence, what evidence is the court using, do the judges understand, do the prosecutors understand, do the defense lawyers understand, do the suspects and the victims understand their rights? I mean, this is what we say is the magnitude and scope. Yeah? So we are saying it is not limited to crime laboratories or criminal investigations, but rather constitutes a broad multidisciplinary system that operates across numerous governance sectors. And the forensic laboratories only presents only one component of this broader system. And the bill talks about analysts, but you have all these other scientific practitioners and experts. In law, how will you describe them? So that is magnitude and scope. I want to open forensic examinations. One moment, please. I just want to share with you a document on forensic examinations and their costings.
Just give me a moment here. I'm trying to find it. Since I visited here, you see my internet is stuck.
You don't need your internet. Open the folder. You didn't download it.
I must have. But it's not.
It's not opening.
I wish someone would be there.
Can we ask questions? Are you ready for questions?
Do you want to go ahead? Then we can show them later.
And answer feedback session. Question answer feedback session. Mambo nyeti, mambo mazito. Simplifying it kama sisi bado tunajaribu. You can imagine what then public participation effective is required for people who participated in those forums where the government or the ministry went taking views. You can imagine what was required of them. Yes.
Thank you very much. I know this is really encouraging, but also really deep in terms of science and class. So some of us are not very good in science, but I wanted to really say, even as we move forward, I've seen the program. We are over and above what already we are discussing. We are beginning to think through, the National Corona Service has not been implemented, or implemented but not operationalized. So one of the questions we would be looking at, if at the point of this proposed bill, we had the Corona Service operationalized, what would be those things that would already have been addressed? So I think that's really important. We need to look at that. This is something that has lasted for 7 years without operationalization. So then this next question would be, if it has taken 7 years without the political goodwill, will this see the light of the day? Then the other thing, I'm part of Police Reforms Working Group, where Wangu Kanja Foundation also sits. And we, with the support of Katiba Institute, have looked through there's an NPS proposed amendment bill which delves into many other things, as Dr. said. But part of the challenge there is the question around territory and mandate. The proposed amendment bill reads a lot in terms of mandate from IPOA and from the NPSC. But from IPOA, it's largely questions around investigations which speak to forensics as well. So what happens, we need to do at some point. I know Wangu is here on the team. We had prepared our discussions around a submission on the same to think through what has been proposed the other side, and does it speak to some of this? Actually, it speaks a lot to this bill, but in terms of security and in terms of enforcement and in terms of admin, but not in terms of the science of it. Then also there's the proposed, the IPOA amendments. So I'm talking about the NPSC and the IPOA proposed amendment so that we don't mix this. I know there's also amendments around the National Police Service Commission. But the most critical ones are the ones around IPOA and the ones around NPSC, NPS, because we know about the DCI and the DCI lab. So those could be the things we need to think through. I know you are not finished, but it is going to be extremely critical to begin to think about that and then finally see, as you say, all those are being domiciled at the Ministry of Interior. Someone would want to ask whether we have a Ministry of Health in this country that everything is running to Interior. Thank you.
Okay. Concern, question?
I'm just curious, and if you dealt with it when I stepped out or if it's coming up, but so what comparable jurisdictions should we think about in terms of possible good practice? So I saw the analysis of how other jurisdictions have, you know, the different methods that they have, mixed, independent, etc. But what comparable contexts have dealt with what is such a big issue in a similar and logical way that we could possibly consider, especially given that we are a post-colonial constitutional democracy. So, you know, that already in and of itself implies that our legal framework looks a particular way. So are there other potential jurisdictions that we could probably look at? Of course, taking into account that we have to make it fit for purpose, but where else could we possibly consider? Because from your presentation, what's sticking out for me is all of the ways we fall short, and just how much needs to go into developing a comprehensive framework so that we don't continue in the trajectory that we have been when it comes to not only for forensic science and forensic services, but I think across our legal framework, we tend to deal with things piecemeal instead of considering what the bigger structural issue is and how you fix it at that level, and then that sort of cascades down. So, you know, where could we possibly start to look and think about that we can adapt for our context?
Okay, let me address your question first. So first of all, it's not, I know it seems like we're just presenting how big the problem is and how bad it is. Unfortunately, Dr. and I have sat in that position because of our level, our qualification. So we see things in procedure, practice, and policy
But because we are not lawyers, that's something we struggle with, and we know we can't, there's no way we can sit, even if we got 2 law degrees, we can sit in the room and figure this out. So it's not intentional, it's because we are also saying that we are missing that research. The other issue is, so I'm just going to give several examples. So I think because we are a post-colonial, ex-Britain, country, we should look at how the UK is doing this. I think in terms of the regulation part, I think we could benefit a lot as a context to understand how the UK's regulation system is working. And across the board, the UK, Europe, the US, regulators in forensic science will somehow all be on the same tangent. So there's one way we do cardiothoracic surgery, and that's the way we all basically do it. So I think for regulation, because we are ex-Britain, I think we should look at regulation in 2 contexts. One, the UK and Australia. Australia has a very strong legal medicine and human rights approach to its forensic science. It really holds, highlights that component. So I think that is a good place for us to understand how legal medicine, whether it concerns deceased persons or it concerns gender-based violence, will be dealt with. And Dr. is actually a graduate of the Australian system, so she actually understands that pretty well. But I think we would benefit if we were to say today we want to go around and we want to benchmark, we want to look at, we want to observe and understand, then for regulation, UK and Australia would be probably the place we need to go. If we're going to say we need to understand how forensic research is conducted, in the US, the National Institute of Justice is the one in charge of writing the forensics science strategic plan. It is the NIJ. It is the justice. It is a research that is judiciary ordained, if we can use that word. They're the ones who write the forensic strategy, because the judiciary, the prosecutors and the defense lawyers, that system, that ecosystem is the one that is the beneficiary of what we are saying are these 7 steps, of what we are saying is the magnitude of scope in terms of civil and criminal proceedings. So I think in terms of research, we need to look more the United States. They also have something called the National Institute of Science and Technology and OSAC, which is a registry of best practice. So in terms of best practice methodologies and approaches, and scientific boards and advisory and research, we can look to the US. I think in terms of examination, I wanted to share, I don't know, sorry, there was another question. Okay, so these comments about the National Police Service, there's an amendment bill. I mean, these documents, like we said, we need to sit in a legal room so that you can have our forensic advisory understanding. Otherwise, it becomes, these laws need to be harmonized. They need to speak to one another. So for example, it's the state's mandate to investigate crime. That's what the Constitution says, right? Then it is in the NPS Act, it says that the National Police Service function shall be to conduct forensic analysis. So, you know, like, so some things are to us, like if it's a state's responsibility to investigate crime, does then the state outsource our lab? You get, those are the things we're looking at. And if you say you conduct forensic analysis, should we assume that those include all 7 steps? Crime scene to courtroom, or it's just forensic analysis. So we're just saying that things need to be harmonized. So I'd like to, these documents will be shared with you.
maybe you can just remove this. We want to share with you this Forensic Examination Act is an act of Estonia. This is a very interesting document. We really liked it. It is a Forensic Examination Act that provides the legal status for forensic experts, state forensic institutions, and officially certified experts. So it says state forensic institutions. So for them, forensics is state-run. Now the issue of autonomy, those are now issues that we should be able to consider. I think, I don't know, maybe Dr. Kizia has a contrary opinion, but I don't think we are ready for a devolution of an already fragmented system. We just need to figure out how in the governance framework do we make this impartial. So the forensic examination, it says forensic examination is a professional activity of a person who is appointed an expert in proceedings which purpose is to study materials presented and based on the expert assignment provide a scientific expert opinion. They then go to define who's an expert opinion, what's an expert opinion, who's an expert, and it then goes to talk about forensic experts, state forensic institutions, the competency of these institutions. Right now, the bill does not actually give us, apart from several terminologies, it doesn't actually say that this will be the scope of examinations conducted. Maybe it is assumed by the terminology. The Forensic Information Management System. Then it speaks to the National Fingerprint Database and the National DNA Database. So it provides some legal grounding for these. Talks of officially certified experts. Who is an expert? Disclosure, decision on entry into the list of experts, disclosure of the list, termination of official certification, rights and obligations of experts. Here, we wanted to deal with this. This is a major issue. So financing of examinations. So calculation and financing of examination costs for forensic services. Where are we supposed to assume, like are you given a budget, like say 3 billion shillings? Your job is to investigate crime. That means you're saying you will have examination or investigation costs. So what are these costs? So let's go here, say expenses incurred by forensic institutions in connection with conducting examinations, reimbursement of expenses, okay. Prices. So the price for medical forensic toxicology examination is 95 euros. DNA examination, 57 euros. Forensic medical examination. Forensic medical committee examination. That means a committee sits on a case to provide an examination and a proper report. Like the way Dr. and I have had to conduct reports, we conduct them as a team. Because what she does and what I do need to be peer reviewed. Like we need to be like, that's correct, we shouldn't do that, we should do this. Right? So you have a committee examination. That will cost the state of Estonia 271 euros. They have pegged it. This is the cost. Minors gynecological examination, 129 euros. Adult gynecological examination, 109 euros. Okay. Forensic psychiatric and forensic psychological complex examination, 380 euros. A basic one, 125 euros. For the committee to sit, 380 euros. Forensic chemical examination, okay. Alcohol examination, blood alcohol, 75 euros. Explosives examination, 81 euros. Narcotic substance examination, 84 euros. You see, once things are clarified, whether we say it's too detailed for law, it should be in policy, wherever we want this thing to be anchored, it responsibilizes the forensic ecosystem and the duty bearers. And that's why it makes sense to be able to then do a cost-benefit analysis, right? All these things need to be done. But you can't just put ad hoc pricing. You actually have to research the context and know how much should How much does the state needs to pay for its investigation into an offense of sexual violence? Right. Technical traffic examination, this one for 57 euros. Forensic examination, accounting examination per one enterprise, organization or legal person, 1585 euros. Fingerprint examination, 663 euros. So all these are actually, this act has actually costed these examinations. Price for studies conducted in state forensic institutions. If it's done in a state forensic institution, for example, you have this determination of fentanyl by gas chromatograph mass spectrometer examination. It costs you 35 euros. So that's why we say there's a bit of reading to be done. There's a lot of research to be done. And we are saying halt. I think at this stage I should just allow Dr. Kizi to, I don't know, are we in for lunch or? Okay, so Dr. can come. So we want to just go, there are some sections of the bill.
Thank you so much for that presentation. I was worried as I was listening and watching and thinking, I would like to know your thoughts in like 1 minute. Your real thoughts. Are you thinking, oh, this is so much, or oh, this is so easy, or oh, what are they fussing about? Yes.
I think in my thinking, I wanted to ask, from the two of you looking at the bill, was there a consideration that this should take the route of a professional regulatory? I can give an example. For example, we have the Advocates Act, we have the Accountants Act, and I think other professionals where the law comes to, of course, regulate that practice. Because what you had mentioned at the beginning is that currently, and I stand guided, is that the curriculum that it is right now, there is no specific curriculum that teaches forensic science. You have to get that expertise elsewhere. So I don't know, in your thinking, do you think this should be led from a point of professional regulation rather than to look at it as the bill presents? Because even the last bill that has been presented tries to mirror what the Advocates Act does to provide in terms of costs, a minimum, but of course now regulates how advocates provide their services. So I don't know, did that come across then now to approach it from regulating a profession, not, I think, what the bill tries to do?
Any other comment? Just one, only one. The three, you want the three? Okay. The boss has said you take all of it.
Okay, for me, I would say just the way you have asked, like, how are you feeling? And I think when I came in, I knew as a SSV network member, what was crossing my mind, even when I was coming for this meeting, was like, there is femicide issues, there is deaths happening, there is children dying and all that. But also when I came in here, I just feel like, how much of this do I know? I am not in an office somewhere. I'm from the community. My role mostly is to do advocacy, give information, create awareness from at least what we happen to get from this kind of forums. Now, if I was to be asked before I came in here about forensic and all that, mine I would say maybe we were at a good place. I don't want to not to be optimistic, but listening to what you two doctors are telling us and giving us the information, I just feel like, wow, we have a lot to do. Before this is done, the bill, all those malekebishos are done and we get the real deal and pass to the community, people to get understand. Because as much as this may look very complex, I believe there's a way we get also to be given information to a level that we can pass to the community. And most of the time you find that the community really appreciate the referral pathways, appreciate the issues to do with sexual violence, how they need to handle a survivor, where to report and all that. I'm saying we are here for a time like this to digest this, and I believe my question is like, how can this be as quick as it can be? You know, we are calling for femicide to be an emergency, to be declared. Like, this is, we cannot have this anymore. And from the community where most of those cases emanate, hospitals, schools, you know, in our community where we are, actually we find that there's a gap. There's a gap. For the first time, I'm getting to hear that we get to say like crime scene. Crime scene is just the place. But we understand a survivor, a person moving as a crime scene. Wow, it's a lot. Let me stop there at the moment.
Thank you. I think we are at better place because, number one, as a country, we have very good experts. What I was thinking, how I'm feeling, number one, the people who drafted that bill, did they have any expert? No. Do we have expert in the country? Yes. Do we have people who can guide us coming up with a very good bill? Yes. Then the other thing, we started by building the roof. We did not consider the foundation, and we have been told that the foundation is very clear. Have we done any research? Do we have any foundation of to why we have that bill? That's what I'm feeling right now.
I liked your recommendation on conducting an audit that would inform our status, the gaps, and what needs to be done. And I think what we need to accompany it is very strong recommendations on resourcing. So maybe anyone is able to do that could also consider maybe getting actuarials to quantify what that would look like. For instance, I think I heard somewhere, I'm not very sure if this information is correct, but like the issue raised about FGBV, they were saying the cybercrime unit only has 2 forensic experts, and that's the national one, and we do not have county one. So you can imagine all the crimes being reported there. Your device is confiscated to go and be analyzed, and with one engagement we were having with the survivors at the Wangu Kanja Foundation, one was reporting that her device, her phone, has not been returned a year later. But now coming later to hear it's only 2 experts who are doing that for the entire country, you can see it's very worrying. So if we are to give any recommendations, they need to be backed by those extrapolations of how much it would cost. And I'm sure all of us have seen the government pathologist almost in every key issue where maybe there are mass murders or what. His name, I think, is called Johansen. So I think he's also overstretched. So recommendations that would show, for instance, if it's those pathology units, how many staff would they need of what capacity? Yeah.
Thank you so much, Dr. for the wonderful presentation. My feeling right now is that there is need to rope in more of experts. They really love to hear the voice of institutions of higher learning, the universities, and the input on this. We are not, I don't know if they have done any presentation or a memo to what. We feel that this now should be more expanded, and the recommendations that you've already given really need to be considered. Let me confess that when we got an opportunity to look at this as police reforms working group, we actually did not make any memorandums. We just say there's need to look at other legislations that drive or relate to this, so that the matter can come out strongly. That's what we did, and we sent it to Parliament. So it was like a challenge to them, so that it triggers their thoughts towards either halting the process or calling people into the room as you are suggesting. Thank you so much.
Okay, thank you so much, the presenters, Dr. Kizi and Kelsey. And you asked of what are our feelings. For me, I feel good that this is happening. This is a forum that I have been looking up to, where matters forensic, and specifically this bill, can be interrogated more deeply. For me, I come from DCI, and I have interacted with this bill right from its inception, where it started with the government chemist graduating itself to an authority, and they were able, after our first response, they were able to depart from that position to the current position, of which we still have issues with in various forums where we have sat. And I hope I'll get an opportunity to maybe highlight some of the key issues that we have with the bill. But I can largely say that most of the issues are similar to what I have been able to pick for the time I have been allowed. Thank you so much.
So I want to thank you, everyone, for sitting in and listening, because one of my concerns is we are being distracted with other legal frameworks, and we are not keen on the one that will actually make or break a case. And I'm saying that from an organization that works to support survivors of sexual violence. Majority of the things that we are highlighting here will actually contribute in making a case or destroying a case. And most of the time, we put the cart in front of the horse. We work on the legal frameworks without developing a policy that, and we always come back and ask, who were the people thinking of developing the legal framework before developing the policy? We are citizens. We have the right to ask questions, to interrogate, and then also inform such processes. And for me, it's a milestone, but then the bigger question is there political goodwill to actually sit down and listen to the citizens to ensure that the legal framework works for them? Because we are developing the legal framework for Kenyans. It's not for government. It's for you and I. Because at the end of the day, for us to be able to access justice, we need to have legal frameworks that are informed by research and evidence that we can always go back to and say, the reason why we have this provision, it was informed by this. So the question is to us, are we willing to go the mile to make sure that each and every legal framework that we have is actually working for every Kenyan? Currently, as is, the bill does not offer comprehensive support to survivors of sexual and gender-based violence, especially where sexual violence will lead to death, or sexual violence has multiple violations, because it's always about the high level issues. For example, we are looking at counterterrorism, we are looking at other things that do not touch on the human being. How do we bring the political goodwill of, that means parliament and other political leaders, to understand when you are developing a legal framework, it's about the human being. Where is the human being in this conversation? Because when we are talking about environment, sexual and gender-based violence, we are talking about security, we are talking about all those, the list of issues, social issues that are there. Where is the human being in all those issues? Because we need to make the law for the human being, and we need to have, it needs to be people-centered. This is a right direction, but then we need to push back and ensure that any law or any document that is produced by whichever entity or government agency, it has the person at the heart of the conversation. And we need to ask those difficult questions. Thank you.
Okay. We shall, in the next 3 minutes that we have, I will only respond to 1 or 2 of them. Okay, so there's been a lot of talk about, first of all, let me make a correction about universities, yeah? We have universities that offer forensic training programs. Not that we don't have, we do. The question is, what is the quality of that training? So I remember some years back when I was still a police surgeon, these clinical officers showed up at the door, and they told me, Dr. Shako, we are students at a certain university. We were told to come here so you teach us how to examine the genitals in rape cases. Yes, I am not joking. So can you teach us? Please note, I'm surrounded by survivors, suspects of murder, and all manner of things. And I had no idea what they were talking about. And so we then discovered there is actually a master's in forensic medicine at this particular university. These trainees were graduating that year. Yes, and they did not know how to examine the genitals, which is a very big part of the outcome of a sexual violence case. Do you agree or not? Yes, it is. So we asked ourselves, amongst ourselves, those of us who have done forensics at master's degree level, do you know who is teaching here? Do you know who is teaching? No one had a clue, only to find out that it was another, anyway, the people who are training had no training in forensics in terms of theory, practically, experience, nothing. I don't know where they got notes and decided to start this program. What happens now? Fast forward. A few months later, a colleague calls me distressed because there's this person who has a master's degree in forensic medicine from this same university who she is watching messing up evidence left, right, and center. In fact, in this particular case, there was a gang rape case where all the survivors knew, don't shower, don't change, don't go to hospital, immediately call the police. They did their part. But the medical facility, the evidence was destroyed. The next day when police did their part, came for this evidence, they couldn't find it. It was gone. And that case just ended like that. There was nothing else. So the issue is that we have a lot of training, but we don't know who is training. We don't know what they are training on. And most likely they don't have the forensics is very practical. You have to practice what you read. You read, you practice, you read, you practice, you go for fellowships, you work with other colleagues. That's how you learn. So that's the problem. Then also there was something was said about femicide. I just wanted to add that when it comes to femicide, it's important to know that many times femicide is the most grotesque end result of GBV, right? Before that, there are many instances of sexual violence, physical violence, and so on. Now, globally, there's something, and I'm sure many of you know about, the UN Statistical Framework on Femicide and Feminicide. Are you aware of it? You are, right? Something that we have asked severally, especially over the last 5 years because of the sheer number of women and girls who are killed on a daily basis, is our Ministry of Health, our mortuaries, recording specifically how many females were brought in on every single day, every week, every month. Is there a single register for these cases? Do they document all the features and factors relating to this particular death? Why do we not have a femicide observatory that's looking into these cases so we can generate data, right? Because you need data to have interventions. So that's something that I think the statistical framework is something that should probably even be captured somewhere along this discussion so that we are able to properly understand the issues that we have regarding this issue and how the forensics is coming into it.
There's also this issue of county labs. I think before we are not at the stage where we, even at the level of the national government, we haven't had this research and this consolidation of our critical thoughts on this. So the idea of having county labs, it's wonderful to be able to have labs, but the forensic architecture is expensive. It's also very tempting for corruption. Because if you know one machine can cost around 9 million shillings, yeah, everybody will be buying them, right? And inflating the cost to maybe like 20 or 25 million or whatever. I think we really need to ask ourselves, we've also had this conversation of people saying, can we open a DNA lab in a hospital? It's very dangerous for contamination of DNA evidence. Because there's bacterial DNA from diseases in the hospital, there's viral DNA. You will contaminate the DNA of the victim, the suspects, like you will contaminate. So we have, that's why we're saying this conversation needs to be, we need a convening of a critical conversation on this matter. Kizzy and I are only today where we are. As somewhat, you might say we are authorities in the field, but in actual fact is because we talk every day, we research every day, we sit down and we share information, we read and we write papers together. We do presentations together is because, so now we can show you, these are the documents we got from this other country. This is why we have a problem, because we're not being able to price our examinations. It's that talking together is what is very important. And this siloing and fragmentation of its law enforcement and its forensics is a law enforcement conversation. It's an Interpol conversation. It's a UNODC conversation on one side. It's only a drug conversation on the other side. It's, oh, for doctors, it's this one. You know, that is not the helpful environment that can allow us to critically think in terms of law, in terms of law enforcement, in terms of medicine, in terms of all the different scopes for the field and all that ISO accreditation and
the rights of the defense, the evidence that is generated from cases. So we need a convening where we all put down our ego, right? We put down, and we just humble ourselves, and we come to the space and we just say, we need to create a law that is good for every Kenyan, because whether we are the ones critically thinking on the table, there are those in the community who depend on us, right? Even as a law enforcement officer or a politician, whoever, whether you're in the upper classes of society or not, that the same law impacts. The same mismanagement of a case will happen because we haven't created the system processes for accountability. So I think we should be a bit wary about county labs. I think one of the biggest things we need to do is find out how we have an impartial, autonomous, independent governance framework for this issue, and then how we harmonize all these laws, what laws require that harmonization, how we build the best practice forensic capacity to be able to regulate the field properly, and how everybody just finds their place, whether administratively or scientifically, across the different fields. Maybe just to say that we really do appreciate your comments. Also, thank you for having us. And we have some more stuff to go, but which is now going through the bill specifically. But it will be short. But we are here and we are approachable. So please approach us. And there's no silly question or unwanted comment. So thank you.
We're coming back at 2:30, good people. Enjoy your lunch, continue the conversation over lunch. Let's come back at 2:30.
Can you give us a minute? Not yet.
So we'll just go through the sections of the bill. We'll be very brief because already a lot of the issues have been covered. And like we have said repeatedly, most of this bill is regarding chemical weapons and so on. So when we went, if we look at the short title, you all have seen the bill, right? Or you have access to it? Yeah, so the term National Forensic Science Bill 2025 is clear. You can understand what the bill is about forensic science. Yeah, our understanding is that it relates to all matters forensic science disciplines. That's the impression that it gives. If we move to the interpretation, this is where we have the definitions of the various terminologies that will be used in this bill. So we did not capture all of them, just the ones that we thought were critical. So analyst, an analyst means a chemist, lab technologist, physicist, or any other scientific discipline relevant to forensic science deployed in the ministry responsible for matters relating to internal security. So that definition presumes that the forensic analyst can only be from the Ministry of Interior. Is that your understanding? Where are the other professionals anchored in the broad spectrum of forensic science and evidence management? So that's the forensic medical examiners, the dental examiners, forensic researchers, forensic geneticists, accounting, food, forensic, who else can we think of? Accounting and those who look at cybercrime and all that. So any other forensic professional with at least a bachelor's or master's degree in a forensic science should be considered as a forensic analyst. This is a glaring gap. So our proposed definition would be an analyst should mean a practitioner carrying out a specific discipline relevant to forensic science and its related fields. Because then it sounds broad enough. A forensic expert is a person who is qualified to conduct examinations or investigations within forensic fields. This was the other option for something else that can be added or it can be replaced, because again, who is an analyst? When you hear analyst, what do you think of? You think of a lab, data, such things. So it's not really in keeping with the broad spectrum of forensic sciences. We also thought, why not, because of, by these two proposed definitions, we have an analyst can be non-experts and experts can be forensic personnel, whether independent or working for the state. So if there needs to be a separation here, like who is an analyst and who is a forensic expert, who are forensic professionals, who is a consultant, That difference matters a lot, not only in a lab, but across all sectors. It matters. And I think we have talked about it in the morning, how this question of who is an expert, it's a very important question. And we've seen in the Estonia Act, there's a whole section just on who an expert is. What are their qualifications? What are their experience requirements? What are the prerequisites to be called an expert? Okay, the second one is an analytical report, which means a certificate of analysis or a report made under the hand of an analyst. Now, this definition implies that analysts, as per the definition above, provide analytical reports. So where does this leave other documents, such as medical legal reports? Is it P3 forms, PRC forms, P23 or autopsy forms, exhibit memo forms, and other forms in various other sectors? Are these then not analytical reports? The analyst definition captured in the bill contradicts the issues of labs in the bill. The bill implies that any person can be registered and licensed to operate forensic science laboratories. Going by the definition of analysts, who then are the people working in the lab, in these other labs that are mentioned in the same bill? If you look further down, you'll see that the bill talks about a person can register a forensic science lab. Did you see that? What was your understanding? Who is a person? Is it you, me, him, her? Like, are they then analysts? And then, you know, I thought they really need to rethink how they phrased it and designed it, because it's leaving a lot of confusion and unanswered questions. So we proceeded. For instance, Dr. Kalabi Labs or Lancet Labs conducts toxicology analysis, right? You don't want to go to government chemist for whatever reason. You want it to be assessed by someone external, not government. So if they are not employed or deployed by the Ministry of Interior, thus they are not analysts. So what happens then? Are they then not subject to this bill because they are not deployed by this ministry? Is their analysis then disqualified because they are not technically analysts as per this bill? And does this not contradict the Bill of Rights that allows Kenyans to have access to the highest standard of care and to a fair trial? Now, the reason I brought this up is because for very many years I worked as a police doctor for 10, 11 years, 12 years. And a lot of times I would get calls. To date, I still get requests by patients who have been assaulted, whether it's physically or sexually, to conduct examinations because they don't want to go to a public facility. Yeah? A parent called me to see his daughter who was assaulted by one of the helpers. They said if they have to go to Mama Lucy or, Bagathi, they don't want to do it. They'd rather forget about it. If they have to go to a police station, they're not going to do it. If they have to go to... So we had to figure out the best environment to ensure that this survivor gets examined, evidence is collected, and we are still following the law. Do you understand? So if someone doesn't want to do that, they want to choose a separate lab or a separate facility, what happens then, going by this definition? The other thing that we thought is, does it mean that these private labs that play a role in certain forensic analysis must simply register under the Ministry of Interior and be licensed to provide forensic science services? So basically this section is not clear. There is a case scenario. If a homicide or a sexual offense suspect wants to have an independent assessment of DNA samples conducted at a private independent lab, which many ask for, by the way, alongside the national forensic labs, does it mean then that this sample from the independent lab, the report, is it disqualified or not? How does this work? By the way, we are also learning here. We would love to hear from the legal minds and from all of you, because I'm sure our interpretations are different. So our recommendation was option 1, establishment of independent forensic state institutions. The government chemist and DCI or National Forensic Lab can move, so to speak, into an autonomous position, which Dr. Kelsey has spoken about extensively. As an independent institution, it can then be run by independent CEO who is not a public officer who can then report to Parliament. This way you have independence and may enhance public trust. Option 2, and this is a stretch, I know, but it can be anchored under the Ministry of Justice. We don't have this yet, but we have seen in other models that this is a lot of the forensic labs are anchored here under the Ministry for Justice. This could be considered for future. Maybe this forensic science bill can trigger the, what's the word, to initiate a Ministry for Justice? That one, establishment, yes. The state carries the responsibility to investigate crime at no cost to the victims. This is already in law, right? So will the state then cater for these forensic assessments undertaken at private forensic science laboratories? Or how is it supposed to work? Does this bill also imply that the investigations of crime can be delegated or subcontracted? Is that what we are saying? And again, Dr. Kelsey had raised this earlier. Are we saying that now we are going to establish private forensic laboratories? The third part, the third definition was authorized officers. These are officers authorized to carry out inspection of laboratories according to the definition in Section 18. Section 18 states that the CS shall, by notice in the Gazette appointment, authorize officers of such qualifications as may be prescribed. An authorized officer appointed under subsection 1 shall carry out inspections of labs and activities so as to monitor compliance, compile and submit reports of inspection to the board, and perform such other functions to full implementation of the provisions of this act. So what it's saying then is that the same personnel who are service providers are also inspectors. How do you inspect yourself? The inspector should be a regulator and not a service provider. So this separation of roles again has to be very clearly outlined. The bill also states that authorized officers or inspectors should monitor compliance and compile and submit reports to the board as per the bill. Again, this is the duty of a regulator, not a service provider. So this person, authorized officer, has a dual obligation, which creates a conflict of interest. So the proposed changes again is to have a separate legislation relating to forensic science regulation and separation of duties of service providers and regulators. The fourth one was consent. Consent, according to the bill, is defined as a person who has attained the age of 18 years. The bill does not, okay, before I proceed, what did you understand by that? Consent, when you read consent, what were your thoughts? What, did you have any questions? What were your questions? Yeah, exactly. What is this consent about? The bill does not explain what this consent relates to. Is it consent to have samples collected? In criminal matters, do laboratory staff have the mandate to collect samples? Because we know this happens a lot, and sometimes it can be an issue with suspects especially. Is it consent relating to medical issues? Like it's just kind of thrown there without any context. Number 5, forensic science means the application of science to legal issues. While that in itself does sort of explain what forensic science is, in such a grave matter, in such an important bill, there needs to be a bit more definition. The bill then defines, The bill then defines forensic biology, forensic toxicology, and forensic criminalistics individually, which again was confusing. Why have a blanket forensic science and then you're picking which disciplines to define extensively? Forensic science is an umbrella term for various interconnected disciplines. So this again needs to be thought through. Some other absent definitions, we didn't put all of them, but these are just a few. Forensic examination, forensic evidence, forensic databases, DNA database, forensic information management system, codes of practice, codes of conduct, what does accreditation mean, expertise, several others. The framework also needs to distinguish who is a technician, who is an analyst, who is a specialist, who is an expert witness, and who is a consultant. What are the requirements to meet these various categories? The distinctions must be very clear. Now, if we move to the next section, application of the Act. This provides for the regulation, coordination, management, and provision of forensic science and analytical laboratory services. Again, there must be separation of roles. The bill omits other forensic sciences, clarity on who a person seeking forensic science services is. Who is a person? Should there be a definition on person? Person is an entity, it's a natural person, it's a who, you know. Can any person present evidence to the forensic laboratory? Because again, it says that the forensic lab shall provide services to any person and other things. So in my view, when you are seeking forensic services, this many times is related to criminal activity. So there needs to be statements or sections relating to how criminal matters shall be handled, because as a survivor, a suspect, a lawyer, you can't just go picking and dropping forensic evidence at the lab. Which also brings me to the next, which is sort of, just in case I forget. But this act should also clearly state how samples shall be received and how they shall be moved through the lab. What are the standards for reception, for disposition? Part 2, administration of forensic science lab services. So this is talking about the board composition. If we have read the bill, I'm sure we all have, the board members are primarily public officers, specifically from the Ministry of Interior, Ministry of Health, and ministry responsible for IT and science. Now, keeping this composition and keeping this lab embedded within the police service creates an inherent institutional bias or prosecutorial bias. It compromises the perceived neutrality of forensic evidence, as the agency investigating the crime also controls the scientific evaluation of the exhibits. Again, separation of roles. Is this an institutional bill? Is it about service provision or about governance? Because one entity cannot do everything. Yes, Mirna?
Just to give an example of this, I think this is just my opinion, but when you have Ministry of Interior, Ministry of Health, Ministry responsible for IT and science, in the current context of the way we have seen human rights violations, that to me, that just reads law enforcement. It reads with health, Ministry of Health. When we had the protests, we actually were having problems because there was like a clampdown in hospitals. So patients couldn't get, like people now who had evidence on them, like if there were bullet fragments being retrieved from theater, like it became like it's an issue. Like you can't, there was no freedom for the victims who were, trying to get medical help, also knowing that they have forensic evidence on their person and how that was going to be handled. And people have a right to their medical records. So now the issue is, even if you go into contingency planning for such kind of events, are we saying then public hospitals are not the right place to go, right? Because those issues actually need to be addressed. Yes, we actually even had a case, a private hospital. We landed in this certain county in the morning.
because the patient wanted to be assessed in a case of torture, and the hospital, a private hospital, would not allow us until 4 p.m. to start our examination. And the patient was saying, I want, the lawyer of the patient had to come to say, we want this examination, this forensic medical examination. So we are actually having real problems with the institutions that will now receive these patients who have forensic medical evidence on them. You know, how will this medical evidence be treated at the facility? We've also had situations where people don't know what to do with fragments from bullets, and you find that it was either thrown or it was given to DCI instead of being given to IPOA, or people feeling threatened or people, even patients, feeling like, oh, the bullet, if you're not here, if you don't stand here, the bullet will disappear. Yeah, it's true. We're just telling you what is our real experience with patients.
Which happens even in the mortuaries. Yeah. We've had, in my early days in this field and in the mortuary, if you'd get people who have they are deceased and they are riddled with bullets, and the morticians will be saying, "Hiyo ni police case, wachana nayo. Leave the bullets, leave everything, forget about it." So you see, there's also an education issue missing, and you don't know where those bullets go. Which is wrong. I'm not sure about right now, but those are some of the mindsets that also we have to address at some point in this bill.
Yes, so then the next, the part about IT and science is like there's so much of a leaning towards digital forensics, cybersecurity, intense surveillance, data privacy, and so it's almost like forensics is, is almost being like patterned or fashioned in a way, and I think that we really need to bring the balance back in that conversation. So, with this issue of IT and data science, it just seems it's more of digital forensics, cyber surveillance, and while that is a component and part of forensic work, I don't know if you understand what I'm trying to say, but that bias is already institutionalized in a sense, and there has to be a separation to prevent that bias from being there.
Agreed. So, I think, we can see that the composition of that board is public office heavy, which creates a problem already. And then there's mention about 2 persons nominated by a registered association of private forensic practitioners. Does this association exist? We know about cybercrime or something, right? Now, the problem with this is if you have, you have the police, you have DCI, you have government chemist on the board, you have IG on the board, etc., Ministry of Health, and then you have these cybercrime practitioners. How then do you address all these other forensic discipline issues? How will you provide guidance? How will you provide advisory? How will you draft reports? What will you write if you don't know about those fields? So this creates a problem as well. I also think that there should be a section with prerequisites on the qualifications of forensic practitioners. So it's not enough to be in an association. We are aware of associations that deal with criminal matters, and to think that you need the qualifications to be part of such a board, not just be part of an association. And I think that needs to be added as well somewhere in the bill. 1 person nominated by universities offering forensic science programs. This is now another additional member, right? And the question we raised is, does Kenya have above board forensic science programs? And we have already talked about that. if we are picking, why is it universities to select forensic practitioners to join the board? Because academic forensics and practice forensics are very different. We know a few professionals who have done forensic sciences academically, but until you can move it to the field, you really will not be able to, you'll miss out a lot. It's important that members of this board include forensic practitioners who have experience in forensic work. Okay, the other section here, a person shall be eligible if they meet the requirements of section 23. The eligibility of appointment of the person, if the person has a diploma. Did you see that place? They said anyone with a diploma or bachelor's or something like that who can be appointed. Yes, it's right there. If you open, you'll see for yourself that those are some of the criteria. Any person who has a diploma holder can sit on the forensic board or be employed or deployed to the lab. I was not very clear on that. And that is questionable, because then how is it going to work? How will you regulate others who may be more qualified? The listed area of study states forensic science. Yeah, this must be defined further. Does this include forensic medical services, dentistry, radiology, psychology, etc., etc.? Or is it just what we see, forensic science, physics? Like, it needs to be clear on what they mean by forensic science as a study area. The person must also have 15 years experience. This is a very long time. This section that the person must have 15 years experience significantly limits representation opportunities on the board, because very few people have forensic science experience of that number of years. Which means then what happens if no one meets that criteria? Then it leaves a gap somewhere. Only a handful of forensic practitioners have practical experience and qualification. Now, if we move to section functions of the board, section 6. Section states that the board shall provide guidance on forensic science lab development, on forensic activities, on publishing of guidance and reports on any matters relating to forensic science, and advise the Cabinet Secretary on registration and licensing of forensic science labs, and to perform any other functions deemed necessary. So this whole section does not provide clarity on these other forensic activities. What are these forensic activities? These activities must be very clearly documented. And what's more worrying is that because this bill is very lab focused, these forensic activities could be now involving the rest of the forensic disciplines that play a role in generating evidence that's submitted to the lab. So there needs to be very, very clear explanation on what these activities are, and they should also have their own set of standards. Given the composition of the board, other forensic science disciplines may be omitted from publications and reports, given that the bulk of professionals are omitted as service providers within the bill. Basically, the bill only mentions a handful of forensic disciplines, and thus the rest of the forensic disciplines risk being omitted altogether. If the board can consist of diploma holders in a handful of sciences, then the composition may also struggle to provide best practice guidance to the chairperson on forensic sciences as a whole. It's also, the board composition requires other organizations like civil society, human rights organizations, technical experts, and so on, judiciary or DPP. So this board is more administrative and not technical. So is there room anywhere for the technical advisory section or board or function? Part 3 refers to registration, licensing, and inspection of forensic science labs. Section 8 states that a person who intends to operate a forensic science lab shall make an application and so on. So again, the definition of a person is absent. This section implies that any person can apply to run a forensic science lab. And please correct us if we are wrong, but that is what I understood. The registrar may, before issuing a license under this section, cause an inspection of the lab to be undertaken. From where we sit, operationalizing a forensic lab must come after inspection of the lab is done. It should not be negotiable. It should not be a may issue. It should be there must be inspection of the lab. So this part of inspection of the lab should be a mandatory process, not up for misinterpretation or negotiation, and this needs to be clarified. Further, this section does not mention anything to do with accreditation, transparency, procedures, standards, protocols, processes, external audits, and all these are necessary for the optimal function of a forensic service. Yeah, we already talked about ISO. Section 27, if you look on your end, refers to management of samples, and it states that the forensic labs can manage, retain, and dispose of samples in a manner prescribed in the regulations. We did not find any regulations anywhere regarding the management of samples. There's a lot of reference to regulations that are not, where are these regulations? It's as if they are yet to be developed. I don't know. This section does not provide specific timelines within which samples must go through each of these processes of management, from retention to disposition. We've mentioned that several times, yeah? So this hospital keeps the samples, this person discards them, they throw them anyhow, which is a very important thing, including even if we talk about terrorism. I remember there was a terrorist attack somewhere, and Doc and I had to go to the scene and let them know that the authorities, there were various law enforcement officers from different countries after the attack. And when we presented ourselves, we said, you know, we work for the government, these are our roles, blah, blah, blah. And it was tricky. As usual, getting in is usually difficult, but we went there to look for these suicide bombers because they are human beings, right? Who is supposed to handle a human being? Is it a police officer, military officer? It's a medical person. And so we had a conversation about this, and of course after collecting remains, we met other officers, and one of them said that they had a whole part of the upper limb in their office, in the drawer. Because they didn't know what to do. They were actually in distress. We don't know what to do with this. What do we do? What do you think? So we said, okay, we'll come with you. We go collect and do this together, yeah? So that's evidence. That is evidentiary material. Such things need to be, this whole issue of evidence management is a very serious matter. It should be very clearly outlined. Different forms of evidence, what are they, how are they managed? This section on expert witness, there was mention of an expert witness. Section 30 refers only to the reports issued by a government analyst or government chemist. So does that mean the rest of the forensic disciplines are not expert witnesses, or where does that leave them? Have I forgotten something? Yeah. Part 6 refers to regulations. Section 46, the Cabinet Secretary shall make regulations on generation and sharing of DNA for the DNA data bank. I would like to ask in this room, because I don't know, but we could not find any legislature on the DNA data bank. Is there any? Is there a DNA database law? There is. There is provision, yes, but yes, sir. We can hear you. I can hear, not we.
Thank you. I had already highlighted this as one of my comments. So what we have currently in Kenyan's legislation is that there is slight provision of DNA database in Sexual Offences Act, and this is also limiting because the Sexual Offences Act speak to matters of offences under the Sexual Offences Act. So again, that database, which is again provided for to be under DCI, is limiting by the fact that it is not only from offenses related to Sexual Offences Act, we can get evidence in the form of DNA. We can get DNA evidence even from many other crimes, including stealing, robbery with violence, murder, and so on and so forth. So the law in itself is limiting, and it's a very big gap.
Thank you so much. Yep, that's exactly it. So again, as we had mentioned earlier, issues to do with timelines, how long do DNA profiles stay in the system, which database, all needs to be clearly documented. So generally the bulk of this bill is, the rest of it, we won't go on with the sections because most of it is on chemicals, toxin, and laboratory sciences. Lab operations. The bill may benefit from a change of name to the National Forensic Lab Bill, or revise the bill to include all forensic disciplines, which I think, because we have this wonderful opportunity, it would be good for us to move in that direction. There is no mention of regulatory processes, which we have mentioned. There needs to be separation of investigation, analysis, and regulation. Yeah, I think that's about it. So that brings me to the end of my presentation. Do we have any questions? Dr. Kelsey, is there anything you wanted to cover?
So I think the review on the bill has not ended. But for now, at least, this is what Dr. and I were able to glean from the bill. We also, if you look at the penalties that have been issued in this bill, there are penalties relating to 1 million shillings for the offender, 5 million shillings, 10 million shillings. But members of the board who may not report a conflict of interest would only pay 100,000 shillings. I think that is just unfair. It is highly discriminative. And I think that needs to be corrected. The other thing I would say is to just give anyone, even if today you said, Dr. and I could open this lab, we are a person, right? We can intervene in forensic sciences, but we are a person who decides we want to register, we want to make an application to register for a forensic laboratory, because it doesn't stop us from opening a fingerprint lab. Even though that's not our core specialization, opening a forensic lab is not something that is just easily done. So it will take some time to open a lab, to get equipment. And the Act says that it should, the lab must be open within a period of 2 years. Also, the labs, forensic labs, are high, require a lot of investment. They're investment heavy, So who has this kind of money? And I think the timing of all this is very, I don't know. For me, it just feels it's a bit off. Like, yeah, I mean, if you're a bad guy, then it's convenient, right? If you're trying to be good and right and ethical, then it's timely, it's welcome, but then how do we proceed, which direction? So I think for now, that's what we have. I would like to show you something. As part of my work, I've been involved in an international investigation. I'd like to show you how, maybe just to say thank you, is to show you how we managed
those cases that international human rights investigation. So just give me a moment to set up my hard drive, and then maybe Wangu, you can speak to what would happen next after.
Any questions, feedback, clarification? Menyamaza sana, lazima tuongee. Because I know all the organizations in this room work on human rights, gender-based violence, and accountability. So what are your thoughts, feedback, comments, suggestions?
Okay, for me, I'm not responding to any of the queries, but there's something Dr. Shako had asked about how the courts are receptive about the expert opinion that they bring to court. So in most instances, we call it, the court will actually receive it, but it will look at it, it will look at that piece of evidence, not as looking at it not only as the evidence available, but also the other evidence or circumstances that led to the commission of that crime. So in most instances, you'll find the prosecution has availed the expert, who in most cases will be a government person or officer. During the defense time, they might also avail their expert. In most cases, I think IMLU will bring that person. For handwriting experts, my experience with that, they also used to bring their own experts, and it is upon now the court to look at it independently. Yes, there are two, but it can also call for itself a third, and probably look at the methodologies used, and it will come to its own determination. So it's expected that every expert has that skill, and while giving that opinion, used several methodologies to arrive to a certain conclusion. So just to help the court while at it. Then in response to a concern about when we say we don't have the DNA for other offenses, only for sexual offenses, I kind of beg to differ, because as a state, or when someone is being brought to book for accountability through the court system, and it is I'm a former prosecutor, let me just mention this. Every other day, every investigating officer used to be asked, ulichukua fingerprints zangu? Ulichukua fingerprints za hiyo mahali unasema tuliiba? And in most instances, they will say no. And that was a very crucial piece or opportunity to have collected that evidence for comparison of fingerprints. Because anytime someone is accused or suspected to have committed a felony, they will always take your fingerprints and now forward those fingerprints to the database of not necessarily forensics. I've forgotten the person, but there's an officer who actually runs that data of fingerprints, so that even when if you're a previous offender, you're able to be brought to book, and also the court knows that this is not the first time you're committing a certain crime. So all is not lost, but what we have, we can't say we've been operating in a vacuum. No, there's something. But just that we want to collate it into one document. So all is not lost so far, but we can do better. That is it.
But I guess one of the things that we are saying under the Sexual Offences Act, having the provision for DNA samples is one of the things that we've not operationalized as a country that would actually be helpful. And one of the conversations that we've been pushing for example, if someone committed a crime in Mombasa where you raped someone and then you moved to Nairobi, if they were able to collect and preserve evidence from the victim or the survivor, then they upload it into a system, and then the person moves to Nairobi and commits a similar crime, and evidence is collected, you would actually link the two crimes and hold the person accountable. But now, as a country, we are missing that whole structure, and I know it's possible because the UK have been able to do it, and they have regulations around it, how you collect, how you analyze, how long the DNA samples can be stored. So, like, we have countries that we can borrow from. We have best practices. So we are not starting from scratch. We want to contextualize the different interventions from other countries into our own context. Because also some of the mechanisms that they have might require a very huge investment, which I'm not quite sure as a country we are ready to be able to do that. We can actually do it in phases, and that will save us a lot, especially when it comes to gender-based violence, serious crimes, robbery with violence, where children have been abused and they need protection, because we are missing on a lot when it comes to analyzing DNA evidence. The amount of high vaginal swabs that have been collected in various public health facilities, and they do not get to a police station and then transported to a government forensic lab, they are numerous. We can, like, I've been to facilities where I'm like, okay, so we are denying survivors access to justice, yet we have thousands of samples in public health facilities that can be used to support survivors access justice. So we are always denying survivors justice because we are not willing to make that investment as a country. And I think it is urgent and prudent for us to be able to do that, because the evidence that we collect can also be used to exonerate someone who has been wrongfully identified. So it's not always about making the connection that this person is the one who committed a crime, but then also if someone has been wrongfully identified, we can use the same evidence to exonerate that person. So we need to have a candid conversation, because I think we are not maximizing on the expertise that we have in country, and then also we are not willing to come to the table and have a candid conversation. And I mean, even as government, and when I say government, I'm referring to CI, let me say the whole Ministry of Interior structure, because we have private or individuals who are not within the security sector, who are private members of the public, who can actually add value if you open up that space. We are not taking advantage of psychiatric, forensic psychiatric support. And I'm saying that we have survivors who, because of the crime, they lost their speech. But then on their bodies, you can actually find evidence that can point someone and the individual who committed the crime. So what are we telling one group of Kenyans? They are not important. We are struggling with even connecting, and I say this because every single time we engage with survivors, I keep on asking, like, why are we discriminating the vulnerable persons? There is a child who was defiled, and then the perpetrator ended up hitting her head on concrete, so she lost her speech.
She could not testify. She could not identify her perpetrator. 3-4 years. And then later, because she, in the process, she got a condition, she suffocated in her vomit, and that's how the case ended. We denied her justice when she was alive. We denied her justice when she was dead. So what are we telling each other? The same. A woman was raped in hospital for, I think, 2 months. She lost her speech. We tried as much as possible to see how best we can support her to recover her speech. She never got her speech back. And because the evidence that was on her body was actually mismanaged by the health facility, we ended up not collecting the evidence. She's a foreigner. So we are trying to see how we can actually support her to go back to her country, because right now, even her being here is not helping her. She's not relating with her child, and a child that she was relating with before. So if we have all these mechanisms put in place, we will not be denying Kenyans justice. Those are the only 2 examples I would want to, but there are many. Like we have a database of over 16,000 cases where for one reason or the other, the case is concluded because we did not use the evidence collected to help that survivor access justice. So can we try and see, because all of us are Kenyans, hakuna mtu atahama hapa ende Uganda ama Tanzania. In your current position, you have the influence, you have the power to influence something. You have something to do to change the current situation. We are not powerless. We have the power, we have the right, and we have the opportunities. So can we find something that you can do to advance this conversation? Because if we don't do it, you are the next person to be affected. So beware of the mechanism that you're refusing to address now. You will actually need it into the future, or your children, or other your loved ones. So it's a high time. We just have a candid conversation and see, in my position, what can I do? And push that agenda. Thank you.
Thank you, Wangu, and thank you, everyone, for your attention this evening. I just want to show you something from an international human rights investigation, the kind of evidence quality that's required for ICC level, okay? The kind of level of prosecution of cases or defense checking of the kind of evidentiary samples that would be gathered for such a case. This case relates to death investigation, but it's essentially, it's a type of evidence relating to death investigation. We're heading into elections next year, which means if we look at in terms of contingency planning, right? What kind of evidence are we looking at? Potentially digital evidence? Yes? Are we looking at potential gunshot evidence? Are we looking at potential sexual violence related evidence? Are we looking at evidence from blunt objects that have sharp edges, or blunt objects like rungus, right? So that's a lot of evidence, and the management of evidence that's ethical means that if that evidence is on a scene, it's on a person, it's relating to an object, that the governance framework for the management of that evidence from crime scene to courtroom is well managed, so that you don't have at the end, if anything were to happen, people just saying, yeah, this happened to me, but there's no evidence. It means the state must look at not dropping the ball. Yes. So if we just cut the camera for now, because I'm going to share some sensitive information. So I'm just going to share with you. So, we were invited to a case in a country in Central Africa, and a number of specialists, around 20 of us, lawyers, criminal investigators. So investigators, lawyers, doctors, radiologists, odontologists, anthropologists, pathologists, all forensic, ballistic and trauma specialists, and so there was a case, people were taken, they were detained for a while, for a number, and then one day with they were released from the prison, but not released, but taken out, taken somewhere and killed. So it was an investigation of who these people are and what happened to them. So please don't take any pictures. I'm just sharing with you what an international level type of investigation of evidence, in this case death investigation, looks like. It can be international investigation of evidence relating to something else, financial crimes, fingerprints, whatever, okay? So initially we start, our job is how do we build the infrastructure for death investigation, which means we have to do a temporary setup, right? So we were able to be given this facility, which is part of a hospital. So we start to put up a setup. We need equipment, which means we need money. We start to set up equipment for a makeshift